All right, welcome everybody. Good afternoon. This is the meeting of the Joint Committee on the Judiciary. And we are here today, this afternoon. We have a full agenda of presentations by organizations that appear before our committee. They're here to introduce themselves to us. That will start at 12:20. We have a little bit of committee business to do before that. And we will start with the committee rules. We have asked the analysts to prepare a set of draft committee rules that take into account the COVID addendum prepared by leadership. And I've emailed that to Senator Keim and to Representative Hagan to take a look at, and have also forwarded to members of the Democratic caucus. And I will forward it to Representative Evangelos and Representative Newell in just a moment, so that everybody has it available. And I would hope that everybody would have a chance to take a look at it over the next 2 days and be prepared to vote on the committee rules on Thursday when we convene at noon. The next item of business that we are going to address has to do with LD 15. LD 15 is a bill titled An Act to Amend the Intelligence and Investigative Record Information Act to ensure government transparency and to protect the privacy and safety of the public. That is a bill that in the 129th had been referred to Criminal Justice and Public Safety. It was one of the first bills referred in the 130th, and it was referred to our committee, but the proper jurisdiction is actually within Criminal Justice and Public Safety. But because it's been referred to our committee, we need to take some committee action to re-refer it. And so at this point, unless anybody has questions, I would ask for a motion to re-refer LD 15 to Criminal Justice and Public Safety.
I also move, Madam Chair, to move the bill to Criminal Justice, and I needed to speak briefly to my motion. You'll understand it's not a big deal, but it's something that was brought to my attention.
Yes, you may.
I'll wait for the second and then I'll, if you want.
And there's a second, Representative Moriarty. So first, motion by Representative Evangelos, second by Representative Moriarty, and you may speak to your motion.
Thank you, Madam Chair. I just wanted to bring attention to the committee and probably other committees that I received a call from a member of the Maine Press Association, and I haven't verified this information because I don't use the YouTube, but their concern was that when we vote, they can only see a few of us. So they don't know who voted yes and who voted no. Now, this isn't a big deal today, but eventually, if we continue to meet this way, the press is going to want to know who voted yes and who voted no on bills. They're claiming they can only see a few of our boxes on YouTube. I'm a big believer in hand counts and not going through verbal roll calls because it slows our business down. But perhaps if we're going to use the hand counts, Soupy could announce who voted which way. But Madam Chair, first we need to verify whether the information they gave me was correct, because I don't use YouTube. But second, if it is correct, every committee is going to be facing this issue, so you can bring it up in your chair's meeting. That's all. Thank you.
Thank you. That's a really good point. And I just, for the benefit of the committee as a whole and for those who are watching, we have a voting sheet that lists the committee members in the order that they're appointed. And the process that we're planning to follow is that, oops, excuse me. I just put my elbow on my keypad. The process that we're planning to follow for votes so that everybody can kind of get into the groove of it is that we'll do a roll call vote down the list. And our committee clerk will call the names, and then each one of us will, in the order called, register either a yes or no vote. And I think once we get used to that process, it'll be quite easy and go pretty smoothly for us. And we can check back in and see how it's going later. So that's where we stand on that. I did also want to suggest to committee members, if you want to be recognized, please hold your hand and wave so that I'm able to pick you out on the screen. So we have a motion and a second to re-refer LD 15. Is there any other discussion on the motion? Representative Babbage?
Yes, Madam Chair, could you just restate the title of the bill again for me so I'm sure that I'm voting on what I think I am?
Yes. The title of the bill is an act to amend the Intelligence and Investigative Record Information Act to ensure government transparency and to protect the privacy and safety of the public. And again, it was a bill that Criminal Justice and Public Safety spent extensive time on in 129th.
I will vote if it's the consensus of the committee to do this, but I do think that privacy has been a domain of this committee, generally speaking. But since they've done the legwork on this, I have no opposition to going forward.
Any other discussion? I'll ask our committee clerk to call the roll on the vote.
Senator Carney.
Yay.
Senator Carney, yes. Senator Sanborn.
Yay.
Senator Sanborn, yes. Senator Kime. Senator
Yes.
Kime is absent. Representative
No,
Harnett.
yes.
My apologies. Senator Kime, yes. Representative Harnett. Representative Harnett is absent. Representative Babbage.
Yes.
Representative Babbage, yes. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Moriarty.
Yes.
Geez, Representative Reckett is present, actually.
My apologies. Representative Galgay-Reckett. She's muted.
Lois, you'll have to unmute.
Yes.
Representative Galgay-Reckett, yes. Representative Moriarty,
Yes.
thank you. Representative Moriarty, yes. Representative Sheehan.
Yes.
Representative Sheehan, yes. Representative Hagan. Representative Hagan is absent. Representative Downs. Representative Downs is absent. Representative Libby.
Yes.
Representative Libby, yes. Representative Poirier.
Yes.
Representative Poirier, yes. Representative Evangelos.
Yes.
Representative Evangelos, yes. Representative Newell. Representative Newell is absent. I'll repeat. Representative Harnett. Representative Hagan. Representative Downs. Representative Newell. I have 10 in favor.
Thank you very much. The motion passes and that bill has been re-referred. Thank you, everyone. It looks like we are just a couple minutes shy of 12:20, but if everyone on the committee is ready, we can dive into our first presentation by the Maine State Bar Association. Senator Kime, is that okay with you? Okay, great. Let's start off then our round of meetings and introductions today with a presentation by the Maine State Bar Association. And what I have on our list is Kelly McDonald, who is the president, Jim Cohen, legislative counsel, Jill Kramer, Judicial Evaluation Committee chair, and Angela Armstrong, executive director. And I would ask those folks to do a little bit of an introduction and then enjoy your presentation. Thank you.
Thank you, Senator. Kelly McDonald here. I'll start out. I am the current president of the Board of Governors for the Maine State Bar Association. Thanks for inviting us here today.
You're welcome.
And if we're going around the room, I'm Jim Cohen with Farrell Dana and serve as the Legislative Counsel to the State Bar Association.
And I'm Jill Kramer, a representative for District 1, York County, and also chair of the Judicial Evaluation Committee.
Good afternoon. I'm Angela Armstrong, and I'm the Executive Director of the Bar Association. Thanks for having us.
So what we intend to do today is to give a quick overview of the Maine State Bar Association. And then Jill is going to talk a little bit about the judicial evaluations that we do amongst our members, information that we collect and then provide as part of the confirmation process for judges. And at any point, I'm going to invite folks to jump in with either verbally or in chat with any questions that they might have. Happy to make this as much of a discussion as you would like. Our goal here is to provide you with whatever information we can to explain our role in the various processes. So the Maine State Bar Association is, yes.
I'm sorry to interrupt you, but for purposes in the committee hearing format, we're not using chat. And if you could just ask people to raise hands with questions, and then I can recognize them.
That seems entirely reasonable and orderly to me.
Great, thank you.
Thank you, Senator. And so as the Senator says, if you have questions, please raise your hand. So the Maine State Bar Association is a statewide nonprofit trade association of lawyers. We are a voluntary bar association, which means that you can be a lawyer in Maine and not have to belong to the Maine State Bar Association. And it's my understanding that across the country, when you look at voluntary bar associations, we have one of the highest, if not the highest, percentage of lawyers who are licensed in Maine who have chosen to be members of the association, about 3,000 of them at last count. And we're pretty proud of that. There are some states where the Bar Association is an involuntary association. You have to belong if you would like to practice in that state. That's not the case here. Our mission is to promote the honor, dignity, and professionalism of lawyers, advance the knowledge, skills, and interests of our members, and support the public interest in a fair and effective system of justice. A lot of different parts to that. We make policy by virtue of the Board of Governors. That's a volunteer group of 22 attorneys from across the state. Some of those attorneys represent geographic areas, counties or multiple counties. That makes up 13 of the 22. And then we have additional governors who sit on the board who represent either different demographics, like the new lawyer section or the women's law section, or areas like public service or in-house counsel. Governors serve 2-year terms, officers serve 1-year term. We have an executive committee. We meet as a board about once a month. The executive committee meets as needed. For the purposes of this committee, or what may interest you folks is we also have a legislative review committee. That committee works with Jim Cohen to review all of the pending legislation and to decide whether the association should take a position on that legislation or not. Sometimes those decisions go to the board as a whole, but that legislative review committee is able to act on a slightly quicker timetable. We've noticed that the legislature, things can happen pretty quickly, and we need to be able to respond as needed. And so we try to have an active presence in the legislature on issues that directly address our mission statement. We also have a judicial review committee. You're going to hear a little bit more about that from Jill in just a minute. Let's see, what else do you need to hear about MSBA? Some of the things that we make sure that we do, we provide continuing legal education for lawyers across the state. We provide support to the different sections, for example, family law, criminal law, bankruptcy law. And one thing that might be useful to this committee to know is that those different sections they have their own meetings. They're a part of the association, but they also meet separately. And sometimes those sections take a position on legislation as well. They do so with the approval of the board of the association as a whole. But for example, the family law section might take a position on a bill that affects family law. I'm not a family lawyer. I wouldn't have the faintest idea if that's a good idea or not, which is why we ask the sections to be involved in those matters. So it may be that in front of the legislature, you hear advocacy coming from the association as a whole, or you may hear advocacy coming from a specific section of the association. Well, that's the big picture. I'm sure I've forgotten a couple of things. Let me go over. Oh, I see a hand up.
May I ask, Dan? I have a question about your, I don't know what your overall name of it was, but the divisions in the Board of Governors on new lawyers, women, public service, that section of your presentation. The question that sprang into my mind was, is there any subsection of the bar that deals with diversity issues? Is there any, or have you thought about that? Or whether it's new Americans or immigration or not? I'm just curious as to whether or not there is a subsection of the bar that would look at that issue and is composed of members of diverse groups.
Thank you so much for allowing me to talk about that, because it's an issue that's near and dear to my heart and one that's very important to me during my one-year presidency. In fact, we designed a 2-year strategic plan. We just did that this past fall. One of the 3 action items in that 3-year plan is directly focused on diversity issues. We have a diversity committee, which is made up of members of the board and members of the community. And that committee has met a number of times over the past 6 months. One of its first recommendations that we have since implemented is to create a new BIPOC lawyers section. BIPOC stands for Black, Indigenous, and People of Color. And that BIPOC lawyers section is specifically intended to provide support and mentoring services to members of that community in an effort to address the fact that they have historically been disadvantaged within the legal and underrepresented within the legal community. That section got up and running this past fall, and the enthusiasm for that has been significant. We intend to amend our bylaws to add a seat to our board that will be filled by election of the members of that section. So in addition to geographic representation, we have a representative on the board who is elected by the women's law section. We aim to add a seat that is filled by the BIPOC lawyers section. There's a number of other things that are part of our strategic plan, but it is absolutely top of mind for us. And one of our goals is, one of those strategic goals is to think about how can we increase the diversity of the Maine bar, not just within the lawyer ranks, but also within the leadership, including at the association. Thanks for that question. So let's see. Let me turn it over to Jill then. Jill, would you like to share what we do with respect to judicial evaluations?
Nothing would thrill me more, Kelly. And thanks again for having us on today. And thank you all for your civic service, and congratulations for being appointed to what I can only assume is the very best committee to be on, the Judiciary Committee. So go team. I should know this walking into this conversation. I honestly don't. How it is that that members of the bar get elevated to members of the bench. But as soon as they are, the Judicial Evaluation Committee, which I chair, kind of springs into action. We are a group of 7 members, all members of the Maine State Bar Association. And our task is to recommend for renomination or not those judges who are up for reappointment. As some of you may or may not know, a judge gets appointed by the governor. That person serves the first 2 years of his or her term. And that individual goes through an evaluation process with the Maine State Bar Association Judicial Evaluation Review. And that involves basically a survey instrument. So about January, February every year, our executive director gets a list of all of the judges who are up for reappointment, whether they're in the first 2 years of their term, and that could be as a new appointment. They're new to the district court or the superior court. We don't do probate judges or law court judges. But for those people who are on the lower courts, we get a list of all the folks who are ending their first 2 years, and then again, ending their first 6-year term. And this year, there are actually 17 judges and justices, some of them active retired, who are on the list this year to be reviewed. And so what happens is we disseminate in March every year a survey to everybody. It comes through email, but it's also available in hard copy for those of our lower tech community members. You don't have to be a member of the Maine State Bar Association to fill it out. It's for every member of the bar who's practicing in the state of Maine. And the window for answering these surveys is about a month long. And the surveys cover 6 areas of practice for the judges. And those include, we're evaluating the judges based upon their legal ability, their knowledge of substantive law, the rules of evidence, legal analysis. We look at their impartiality and their treatment of litigants and attorneys. We look at their judicial temperament, integrity, diligence and preparation, there's a special skill category, but there's only 2 on there at the moment: sentencing fairness and competence dealing with family matters, cases with kids. Could be protective custody cases, or just regular family matters. There's room for comment on these surveys. They're pretty quick and easy to do, but actually it's the comment section where we really get the valuable feedback on each of these. We're asking each and every practitioner in front of one of these judges or justices to weigh in. How do you rate these judges or justices in these categories? And tell us any anecdotal stories about a good experience that you had, a bad experience that you had, something that you think is consistently either off or they're doing great. And as far as I can tell, this is really the only feedback that the judges and justices get from those who are practicing in front of them every single day, and for those whose clients' lives are directly impacted by what it is that they're doing. And so the surveys go out. We obviously attempt to get as many responses as we can. It is a bit more difficult in the rural areas where response rates tend to be low because there just aren't that many practitioners in those geographic areas. And this year it's going to be, we're not really sure what to expect because most of us have been benched because of COVID. We're doing a lot of things remotely if we're doing them at all. And so we may be able to rate judges on how the court system has pivoted to something like this. But I'll be interested to see what the responses are. Once the window is closed, we collect all the responses. Our executive director runs them through the software, and a report gets basically spit out. All of the responses are completely anonymous. Every response is confidential. No members' names is attached to these. I don't know who filled these things out. The judges will never know who filled these things out. So good, worse, indifferent, confidentiality is completely upheld through this process. And once the reports come out, my committee reviews them. We go through each judge and justice one by one, addressing each of those topic areas that on which we've asked people to respond, go through the comments, and it's up to us to determine whether or not we ask the Board of Governors to recommend reappointment. And for judges who are at the end of their 6-year term, that information would go up to the judge. To the chief judge in that court system, and to the chief justice of the law court. And it also gets sent to the governor, of course. And for those, some just sail through, they look great in all categories. If anybody's flagged, if there are some concerns raised by a number of practitioners, or even just one that our committee thinks is serious enough to talk about, we bring that to the attention of the full Board of Governors. And if upon discussion it's warranted that this judge or justice requires further investigation, we've left that a little bit flexible by design. It could just involve an internal discussion. Last year we had a judge who came up that had some questionable comments, and so we reached out to the practitioners anonymously that practice in front of this judge and just talk to them about their experiences in front of him or her. Just to get more information, we have at times had judges come in to answer questions. And so we want to undertake a thorough review. As I say, I think this is the only feedback that judges get, and I don't, as I say, know how folks are elevated to this position. I'm assuming somebody nominates them and then somebody's like, yeah, they're going to do a great job. And so it's up to us to fill in what happens after that. And I think of it as really sort of a big job. And so if we're recommending a judge for reappointment, we've got our a report where that judge sees all of the responses, again, anonymously, all of the comments and our recommendation for reappointment or not. If we're not recommending reappointment, as I say, we do a thorough investigation just to make sure we're on the right track with this individual. And then, as I say, the judges get these reports. There's a liaison that's assigned to each judge each year. And so if that judge has any questions, reach out to us. I have never had anybody ask me any questions in my couple of years on this board, but there's a first time for everything. The 2-year judges, it's just advisory. Their chiefs don't get copies of the report, just the judge or justice, him or herself. And that's really sort of, here's what we think you're doing great. Here's what we've noticed could be room for improvement. And hopefully these judges and justices take that to heart and then make some adjustments to their practice based upon what folks are saying who are in front of them every day. What else can I tell you? Oh yeah, the survey questionnaire that we use, as I mentioned, we do hit those 6 areas. It was our intention to actually revise it. It hasn't been revised in a decade or more. Some of the language is a little outdated. Some of the topic areas could be tweaked a little bit. And so it was the intention of my committee, and we kind of fell down because of COVID, to analyze the survey, make sort of up-to-date changes to it. And that is now my goal for next year as well. Our goal is also to incorporate the magistrates. Most of you know that there are family law magistrates in, I think, every district in Maine. They handle specifically family matters. Their scope of practice is very, very limited. And they aren't usually baked into this process, but we'd like to include them. They're just as worthy of feedback as every other member of the bench. And I'm sure they'd find it valuable. Again, these guys, I don't think get reappointed. I'm not really sure, but maybe Angela can speak to what's going on with the magistrates. But as far as I've been on the board, we haven't reviewed them. And again, that's our intention for this year, to work them in. Because honestly, I'm in front of a family law magistrate 10 times more often than I am in front of a district or superior court judge. And so, I think the feedback is valuable. And from what I know, just anecdotally, the judges really do take the feedback to heart. And Kelly could talk about some experiences that he's had with judges really addressing those issues that people have perceived as a weakness and improving their practice because of it. I think it's the judicial evaluation process is an invaluable tool, not just for the governor when deciding upon reappointments and for your committee, but for the judges under review who are able to use that information to address their areas of strengths and weakness and their skills and knowledge. I think that's pretty much all I have to tell you. If anybody has any questions, I'm happy to answer those. It's been an honor to serve as the chair of this committee. I think none of these judges have ever asked me for my opinion, and this is the opportunity to be heard. And I think our bar and bench are so much the better for it.
I think we have a question, Senator Keim.
Yes, thank you. Thank you for that overview, Jill. One of the things that, as long as I've been on the Judiciary Committee, I've heard asked again and again, so I'm going to continue it. But the questionnaire that's put out to the members regarding a judge that's up for reappointment, there's, I believe, limited usefulness of the input when it's just a thumbs up or a thumbs down, as opposed to any more information that the bar, and those working with the judge actually, any concerns they might have, we never know if everyone was in agreement or if just if, the majority was in agreement. So it really doesn't, it doesn't provide as helpful of information as it could to the Committee of Oversight that's really trying to make sure that we're doing our due diligence. And then the first I heard, so I'd like your comment on that, but the second thing is that I think I just heard you say that once the questionnaires are filled out and you've scrubbed them of any identifying information, that you do provide that to the judges themselves. And I don't know, the lack of transparency there for me feels a little uncomfortable, that the bar is rating the judge and giving them their rating, but then they're not sharing that with the public or the committee of oversight. I just, I find that uncomfortable. And so I'd like your comments on both those things.
Okay, well, I appreciate your questions. I'll start with the first one. So we too struggle with, we've all filled out surveys where you have like a 1 to 10 scale. Ours on this survey is excellent to deficient. And it's really just a four bullet scale. And, I take these surveys and I click 5 or 6 on every single one of them. I don't put much thought into it. So to the extent that we're able to sort of market this tool as being your opportunity to provide valuable feedback, if you have an issue with a judge and you want him or her to address it, the comment section is honestly where we mine the most gold. And sometimes it could be just one disgruntled practitioner who had a tough experience with a judge and it's really top of their mind. Which is why we do further investigations for those judges that issues have come up, particularly in the comment section. Although if we do see deficient in a lot of areas, that's also cause for concern and something that would force, frankly, an investigation of this judge or justice. So yeah, to the extent that we're able to encourage people to write their candid feedback on here, and going to your second point about transparency, I honestly don't think practitioners in front of these judges would feel comfortable making a negative comment about our judge or justice if his or her name were attached to it, because we have to go in front of that judge tomorrow and the next day and the next week. And I think it would cause people concern, and I think it would reduce response rates if we were to say, yeah, feel free to make any comments that you want, but the judge is going to find out you said this. As much as we like to think that justice is blind, I'm not sure that a judge or justice could not take negative feedback to heart, or positive for that matter. It could work either way. So if it's your concern that that the attorneys' names aren't attached to these things, that the responses are submitted anonymously, we do log every single response that comes in. So 10 people said this judge was excellent. So, that's 10 people for the excellent column, and 2 people thought he or she was deficient in a certain category. And so those numbers are collected, as well as every single comment. And all of that is provided to the judge. So if the judge sees that 10 people think I'm doing a great job, 2 people think there's room for improvement, the judge has provided that information, but not necessarily with who is providing that information. Although if your county is small enough, you might be able to figure it out anyway.
Jill, if I could just jump in to supplement.
Yeah, we are nearing the end of your 20 minutes, unfortunately. And I don't know, I also wanted to ask Senator Keim if she had a follow-up question. Is the question that you asked being answered?
Cognizant of time, and but no, the question was not quite answered, so I was going to follow up.
Please do. And Kelly, if you've got something to jump in, please do. Senator, please go ahead.
Madam Chair?
Yes, go ahead.
No, so just in a more simple response would be fine, but I guess you are saying that to the broader public, or to the governor's judicial selection committee, or to the judicial committee itself, you provide nothing but an up or down on a judge reconfirmation. However, to the judge themselves, you're providing all of the comments, obviously taking away the attorney's name from those. So that is my concern, is that it seems that it would be in the best public interest for the attorneys, if they're going to make comments and they're willing for the judge to hear them, then why wouldn't they also be willing for the Judiciary Committee to hear those comments? And also the Governor's Judicial Selection Committee. I believe that would be more helpful and more transparent as we go through the process, the really important process of confirming judges.
Okay, I apologize for misunderstanding that question.
Thank you.
I
might have Kelly jump in.
One moment.
Just really fast, I appreciate that input. We will talk about that internally to see if we can give you something more than a thumbs up or thumbs down. Thank you for that input.
Thank you very much for your presentation. And again, to be fair to everyone, we have just 20 minutes per presentation. And so thank you very much to the Maine State Bar Association. Before we move on to the Criminal Law Advisory Commission, it looks like we've resolved our technical difficulties, and I want to give committee members an opportunity to introduce themselves. And in this format, I'm just going to go through the list and give everybody a chance. Just please say hello and what district you're from. So I'm Ann Carney. I represent Senate District 29. I'm the chair of the Judiciary Committee. Next, we have Senator Sanborn.
Thank you, Senator Carney. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Senator Keim.
Hi, Lisa Keim. I represent Senate District 18, which is northern Oxford County and 2 communities in Androscoggin.
Representative Harnett.
Thank you. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner. And I serve as the House Chair of Judiciary. And I am on a new computer after quite an adventure. So hopefully I can figure this out and play along with everyone. Thank you.
We're happy to see you. Representative Reckett. Oh, excuse me, I skipped Representative Babbage.
Thank you, Madam Chair. My name is Chris Babbage. I'm serving my 6th term representing Kennebunk, which is currently House District 8.
Representative Reckett.
My name is Lois Reckett, and I represent District 31, which is the ocean end of South Portland. And this is now my 3rd term and my 3rd term on Judiciary.
Representative Moriarty. Oh, hold on. Steve, you're muted.
All right, always happens. Steve Moriarty, House District 45, Cumberland, and the southern part of Gray.
Representative Sheehan.
Thanks, Senator. I'm Erin Sheehan, and I represent House District 12. That is downtown Biddeford. It's my 1st term in the legislature and my 1st time on Judiciary.
Thanks. Representative Downs.
Sorry, I'm late. I finally got in. I had some technical problems. But anyways, I'm Kathy Downs, and I represent District 130, which is Bucksport and Orrington, and this is my 1st term. Thank you.
Thanks. We're glad you got through. Representative Libby.
Hi, I'm Laurel Libby, and I'm representing District 64, which is all of Minot and part of Auburn.
Thank you. Representative Poirier.
Thank you, Madam Chair. Jennifer Poirier, House District 107, which is all of Skowhegan and a small part of Madison.
Representative Evangelos.
Thank you, Madam Chair. Jeffrey Evangelos, House District 91, and I reside in Friendship.
And Representative Newell.
Thank you, Madam Chair. Rena Newell, I represent the Passamaquoddy tribe of Indian Township and Pleasant Point, and I wasn't aware of any technical difficulties, so I appreciate that delay. I was participating in a tribal leader's presentation to the Marine Resources Committee. That is why I jumped on a little bit later. Thank you.
Thanks for joining us. All righty, so we are going to move on to our next presentation. It's the Criminal Law Advisory Commission with Mr. Pelletier, who I believe is with us. And I would ask everyone else to mute themselves during the presentation. If you have a question, just please raise your hand and maybe jostle it a little bit so that I can see who would like to be recognized. Thank you.
Thank you very much, Senator Carney and Representative Harnett and members of the Committee on Judiciary. My name is John Pelletier. I'm a criminal defense lawyer in private practice, and I live in Reedfield. I'm the chair of the Criminal Law Advisory Commission. Peggy asked that we submit a one-page summary of what we do, and I'll try not to repeat too much of what is in there. But the Criminal Law Advisory Commission is created by statute. It's created by Section 1351 in the Criminal Code, and it really functions. The Criminal Code was adopted by the Maine legislature in 1976, and prior to that adoption, there was created the Maine Criminal Law Revision Commission. And what they did is they studied the model penal code, which had been promulgated at that time by a national organization, and they adapted it to Maine. And so they included in the criminal code the Criminal Law Advisory Commission as a group that was going to, going forward, conduct, in the words of the statute, a continuing study of the criminal law in Maine. And if you look at our statute, under our purview, there's also the bail code, the juvenile code, and we're also to look at matters, administrative and procedural matters affecting the criminal law. One thing I want to point out about the Criminal Law Advisory Commission, we refer to ourselves as CLAC, is that we are not an advocacy organization. So we see our role as providing advice, assistance to the legislature.
What the hell?
And we do take positions on things, but we give our position or our advice to the legislature, and you folks are the decision makers. So we want to provide the best advice we can from people who are experienced in the criminal law, and you folks do with it what you will. We won't be speaking to folks in the hall or sending emails. We to the extent we provide information to the committee, we do so either in writing or at a hearing. Right now, we're generally made up of criminal defense lawyers and prosecutors. There are 9 members. The members, in addition to myself, are Laura Ustack, who's an assistant attorney general. And I want to give credit to Laura. She is the clerk of the commission, and she sets our agenda and does much of the administrative work, and she does a great job at it. Jeff Silverstein is a criminal defense lawyer from Bangor. Meg Elam is a murder prosecutor in the Attorney General's office. Steve Carey is a criminal defense lawyer focusing a lot on juvenile defense in the Portland area. Kathy Slattery is the DA in York County. Andrew Robinson is the DA for Androscoggin, Franklin, and Oxford. Luke Ryu is a criminal defense lawyer in Portland. And Alan Kelly is a former prosecutor and assistant bar counsel now. We have consultants appointed by the Chief Justice of the Supreme Judicial Court from each of Maine's courts. So we have Justice Jabber from the Law Court, Justice Anderson from the Superior Court, and Judge Moskowitz from the District Court. And one of the things we do, we provide information more often to criminal justice, but we do each year provide information to the Judiciary Committee. And over the years, there are certain things or certain themes that you'll hear from us, and you'll probably hear again during this this legislative session. First of all, with respect to sentencing, the Criminal Law Advisory Commission generally disfavors mandatory minimum penalties. So we're very rarely in favor of mandatory minimum penalty. We believe that judges should have flexibility to provide for justice in an individualized manner based on the facts and circumstances of an individual case. Turning to the criminal code, the way the criminal code addresses sentencing is through classes of sentencing classes. So we have murder is onto itself. Murder has a mandatory minimum of 25 years and can be up to life imprisonment. But for the other crimes, they're either A, B, C, which are commonly referred to as felony crimes, or D's and E's, which are commonly referred to as misdemeanor crimes. And each of those crimes in Maine has a range from 0 in terms of incarceration or in terms of a fine, from 0 to, for a Class E crime, it's 0 to 6 months. For a Class A crime, it's 0 to 30 years. And what we try to do as with respect to sentencing, what the criminal code tries to do with respect to sentencing is to classify the extent of antisocial behavior reflected by various crimes, so that the classes of crimes are, when you're looking at a class of crime, you're trying to put into a class of crime behavior that comports with the level of antisocial behavior that is common to other crimes within that classification. And with respect to legislation that often comes before the legislature, there's often bills that seek to increase the classification of crimes. And I would say that on our board, there's a fair amount of skepticism about the idea of what we would call general deterrence, that simply because you raise the maximum penalty, that it's going to make it less likely that people would commit that sort of offense. And so we are generally skeptical of attempts to raise the classification of an existing crime unless there is evidence that there is a problem. And the evidence that we find important is our practitioners, particularly prosecutors, saying that the sentences that are available for this conduct don't fit the circumstances. Or are there judges who are in individual cases who are saying, you know, if I had more authority, I would give a longer sentence, but the maximum is S. And every once in a while, you'll come up, something will come up that sort of meets those criteria, but it's not a frequent occurrence. So when we look at a proposal to raise the class of crime, we're really looking at where is the evidence that there's a problem with the existing classification. Another thing about the criminal code is that in Maine, we have a set of culpable states of mind. So in law school, they call that mens rea. It's what is the bad intent that makes conduct criminal. It's not in most cases, it's not just the conduct itself, it's what makes conduct criminal. And in Maine, the culpable states of mind are intentional, knowing, criminal recklessness, or criminal negligence. And those are core ideas of the criminal code. There are some crimes that are what we call strict liability crimes, but they're generally to be avoided. A strict liability crime would be a crime that does not require the proof of a culpable state of mind. Most crimes do. An example of a crime that does not is operating under the influence, which is a strict liability crime. Even if you don't think you're under the influence, you can still be guilty if in fact the proof is that you are. But generally, crimes require a culpable state of mind. And the criminal code has these culpable states of mind that they have defined and developed over the years. Notably, we don't have culpable states of mind such as willfully or maliciously, which many other states have laws that are crafted in that fashion, but we don't use these terms in Maine. If something we're going to address criminal conduct, we use the conventions that we already have in the code. Similarly, when drafting legislation, we think it's important that new legislation use words and phrases that are already in the criminal code and defined, or are already are undefined terms, but terms that have been in the criminal code for a longish period of time. That way, practitioners have become familiar, lawyers and judges have become familiar with the meaning of those words and phrases. And so when we see a proposal, we always try to urge the legislature to craft that proposal in terms of the drafting conventions that are already in the criminal code. And so I was told to leave some time for questions. So I'll stop with that. I'll just say a couple more things. We do during the session meet twice a month. We generally try to meet every 2 weeks. We try to review bills that affect criminal the areas that I mentioned, and we try to provide written testimony prior to the hearing. Sometimes it gets hectic and we're not quite able. We're a volunteer body to get it always before the hearing, but before the work session if before the hearing is not possible. And we are always willing to respond to requests for assistance with respect to matters that are under discussion. So the members of the Criminal Law Advisory Commission and myself look forward to working with the legislature throughout the year.
Thank you very much, Mr. Pelletier. I think we have time for 1 to 2 questions. Let's see, I see one hand up, Representative Evangelos.
I'm not hearing.
Jeff, I think you're muted.
Thank you, Madam Chair, and thank you, John, for the presentation. And I'm gratified to hear that you're looking at sentencing. I only had one very quick question. I thought I heard you say that for the crime of murder, the sentence could go to life sentence. Is murder the only crime where we apply the life sentence to?
There is the crime of aggravated attempted murder. So even with respect to murder, although the statute says you can have a sentence up to life, the law court has, by case law, created criteria that are necessary to be fulfilled, one or the other of the existing criteria, for the imposition of a life sentence to be affirmed on appeal. And in the aggravated attempted murder statute, those criteria have been put into the code. And if those criteria are satisfied, then life sentence, I believe, is available for aggravated attempted murder. And with respect to a small category of sex crimes, there is not a life sentence available, so that a judge could say that, you know, the sentence is life, which in Maine means you'll die in prison unless pardoned. But there are a small category of sex crimes where the available sentence or the available length of supervised release is any term of years. So unlike a traditional Class A crime that has a maximum penalty of 30 years, there are a small category of sex offense crimes where the sentence could be up to any term of years.
So, and real quickly, aggravated attempted murder means that the person didn't need to die for the criminal defendant to get a life sentence.
I believe that's true.
Okay, thank you.
Thank you very much, Mr. Pelletier, for presenting today. And we really appreciate you appearing before our committee and look forward to seeing you later in the session.
And if I could have just one more second, I do want to mention, when I mentioned the folks on the group,
that information we've got, we just can't utilize other groups' times, but please do send me an email and I'll disseminate it to the committee if you'd like.
All right, thank you very much.
And our next presenter is the Maine Commission on Domestic and Sexual Abuse, and that is Chamo Hunt, and Lucia is here today, I believe.
Hello, good afternoon.
Hi, it is very nice to see you. Welcome to the Committee on Judiciary, and we are looking forward to hearing from you. And are you open to taking some questions toward the end?
Absolutely, yes. And please, I have, just a few things to sort of go over as an overview, but I'm happy to have questions throughout. That's absolutely fine.
Okay, so committee members, just raise your hand for questions. Thank you. Go ahead.
Wonderful. Well, good afternoon, Senator Carney, Representative Harnett, and members of the Joint Standing Commission on Judiciary. I'm so pleased to be here today, this afternoon, to introduce you to the Maine Commission on Domestic and Sexual Abuse. My name is Lucia Hunt. I'm an attorney at Pine Tree Legal Assistance, and I've been a member of the commission since about 2010, and the chair since the summer of 2016, sometime around there. So a little over 4 years at this point. I've had the opportunity to appear before this committee in that role several times, and I'm looking forward to this new and different approach to being in front of the committee. So thanks for having me in this format. The commission exists by statute. It's actually in Title 19A in the Protection from Abuse portion of 19A. It has existed since 1990. We were hoping to have a little bit of a 30-year celebration last year, but those plans got put on hold, just like so many other things. And so hopefully at some point we'll have an opportunity to celebrate the good work of the commission over the last 30 years. But it hasn't happened quite yet. And the commission's statutory charge is to advise and assist the executive, legislative, and judicial branches of state government on issues related to domestic and sexual abuse. That can sometimes include making legislative and policy recommendations. And of course, in practice, that means you'll either see me or another member of the commission appear in front of this committee to talk about specific pieces of legislation. The members are many. We have 36 members currently, including representatives of the Domestic Violence and Sexual Assault Coalitions, the leadership of the 3 commissions, our members, a mental health provider, victims of sexual assault and domestic violence, a district attorney, a police chief, a sheriff, attorneys, a representative from the AG's office, the state police, and either the commissioner or the commissioner's designee from a number of different government agencies, including the Department of Health and Human Services, Department of Public Safety, Department of Education, Department of Labor, and Department of Corrections, provider of batterers intervention services, and 4 members representing underserved populations. In addition, since the last time I was in this position doing this presentation, we have changed the composition of the commission to include 4 new representatives from tribal communities. That includes the director of a tribal coalition against domestic violence and sexual assault, a representative of tribal government, tribal police, and tribal courts. So that's been a big shift over the last couple of years. To have some parity for tribal members. And I think, given the changes in the way that we've been meeting, also virtually, of course, over the last year, that's kind of an ongoing process. The members were formally confirmed as part of the commission, but I think integration of those new members is still an ongoing process, which I'm looking forward to continuing this year. That's kind of one of our priorities this year at the commission. So our meetings are open to the public. They're always attended by both the members and non-members. There's some frequent guests, and then we sometimes have folks come and do different presentations on different topics. The commission also establishes the homicide review panel as part of the statute. So that panel meets separately and comes out with a biannual report, which I believe you will be receiving in the next several months. So that sort of is a part of the commission, but meets separately and produces a report about the homicides, particularly domestic violence homicides, every 2 years, and some recommendations. So the commission, can provide some comprehensive feedback on initiatives related to domestic and sexual violence. We've been asked to produce several studies by both governors and the legislature, as well as be participants on other studies and reports related to sexual and domestic violence. And the best way to contact us is probably just directly through me. We are sort of housed in the Department of Public Safety, but I'm the person who's really the point person for the commission for any initiatives. We'd be certainly happy to look at anything that's coming up or any questions you have. We often have done some research or have some background in many of the issues that we see coming up sort of over and over again as in the legislature. Recently, last year, throughout a few disruptions that happened in the spring, of course, but starting last fall, we convened.
It looks like we're having technical difficulties. Lucia, can you hear us? Let's just give her a moment to try to reconnect. Not sure quite how to deal with this technical situation. I think that she is, okay, looks like she's logged off and we'll try to log back in. So let's just give her a moment to do that. Thanks for your patience, everyone. Representative Reckitt? Yeah.
While we have a second, I just want to tell people that I was involved on the commission for its first 20 years or so. And so if anybody has any questions that don't get answered, but now Lucia's back. So, okay, fine.
I'm just going to call that 2021. I used to call it 2020. I apologize. I'm not sure what happened there.
Go ahead.
But I'm back. I think I was just in the middle of talking about our recent projects and some firearms relinquishment work that we were doing. So we have worked with the Administrative Office of the Courts to create some new judicial branch forms, some new processes, some new protocols, all of these within the existing laws that were already in place. We had some really strong laws. It's just that the implementation of those laws as it related to firearms relinquishment had left these gaps that, you know, we talked about many times in many different ways over the course of several years, and finally just put some dedicated energy towards making some connections to fix those systems gaps. So that's been a large part of the work that we've done more recently. As I mentioned, COVID did interrupt our meetings a bit. We typically meet 10 times a year. We did meet, I think, 5 times last year. So just about half of what our normal meetings would typically look like for formal meetings. And then we did a lot of work that didn't involve the formal meetings, you know, because everyone's got a lot of Zoom meetings going on and we want to make sure to focus our energy in the best way possible. Some other past projects have involved economic abuse studies with MCEDV, looking at electronic monitoring, risk assessment for domestic violence, and batterers intervention programming, just best practices, just to name a few. And so that's sort of what we've been working on lately. The commission priorities, I think, for this legislative session at this point, we often end up, you know, responding to several initiatives related to domestic violence or sexual assault as the session goes on and as we look at those pieces more carefully. At this point, the one that we're very focused on this session is LR 1600, which is an act to clarify and recodify means protection from abuse statute, which I certainly hope to have an opportunity to speak with you more about and would be happy to answer any questions about it. I'm not going to spend a ton of time on it now, except to say It's really just a reorganization of the protection from abuse statute, not a substantive fix of any of the sort of pieces of it, but rather a way to clarify it and make it a little bit more accessible, because over time, you know, there have been additions and it's starting to look like the main farmhouse that had the, you know, original piece, and then you add this, and then you add that, and then as it turned out, it was a little hard to navigate. So it was a project that I worked with several other folks over the summer and came up with just a reorganization of it that hopes to really clarify what that look. Here I am talking about it. I said I wasn't going to, but that's the commission's major focus for legislation in this session. We're also, you know, of course, aware of all the criminal justice reform initiatives that were started in the last legislature and are continuing now. And we're also wanting to develop a framework for the commission itself to make sure that we're analyzing legislation and making recommendations with an anti-bias and anti-racism lens. So we're working to incorporate that into our analysis of legislation and our recommendations. And another initiative that may be on the horizon, which we often do after a homicide review panel report comes out, is to try to implement some of the recommendations of the homicide review panel, if that's possible, if it's sort of within our capacity. So that's really all I had to share, and I'd certainly be happy to answer any questions or talk more about the PFA reorganization.
Thank you very much. Do committee members have questions? Representative Moriarty?
I think you're on mute.
Lord, if I ever get this right. Lucia, you're a member of a statutory commission, and I'm looking at our weekly schedule, and we will hear ultimately from the main coalition against domestic violence and the main coalition against sexual assault. Do you all work together?
The commission is the place where we do that, yes. So the executive director of each of those organizations is a member of the commission by statute. And it's an opportunity and a place where the coalitions work, you know, with all of these other members of the commission. And so when we're looking at things that are really multidisciplinary, we have these perspectives from the AG's office and from law enforcement. And so it's a place where we can sort out some of the intersecting issues related to issues of domestic violence and sexual assault. Yes, we work together very closely.
Okay, thank you.
Thank you very much. Any other questions from members of the committee? I do have a question. Could you, have you already prepared the homicide review panel report? And do you know whether there will be policy recommendations in it this year?
So I don't sit on the homicide review panel, but we have a representative who sits on the commission who sort of makes that bridge between us. I know that the report is very near to completion and publication, and typically it does involve many policy recommendations. So I would expect, although I have not seen it yet, that it will.
Thank you very much. Other questions? I think I'm just going to toggle between screens here. I don't see any hands raised. Thank you very much for appearing today before us and for surmounting the technical difficulties. You did really well. And we look forward to hearing from you, especially in connection with the recodification of the PFA statute. Thanks for your work.
Thank you so much. Thank you so much for having me.
All right, so that takes us to our next presentation, which is the Probate Judges Assembly. And I would just ask that for folks who have already appeared and given their presentations, if you can log off and watch us on the YouTube channel, that would be terrific. That allows us to more easily admit more folks who are in the queue to give a presentation. Thank you very much. And with that, I will turn it over to Judge Libby Mitchell and Judge Will Avantaggio. Thank you.
Good afternoon, Senator Carney and Representative Harnett and members of the Judiciary Committee. Thank you for this opportunity to tell you a bit about, in a very condensed time, what the probate court is about, but I'm sure many of you know a lot about it, and we have submitted the one-page summary, and on it I listed the 16 judges. There are 16 judges. Their experience ranges from one judge who was just elected to his 12th four-year term, and we have two brand new judges, and my name is Elizabeth Mitchell, and I was just elected to my second four-year term. So with that range of experience, we try to help one another with education, with CLEs, and with questions that come up about cases that come before our courts. The Probate Assembly is a loose-knit organization, and we do meet at least twice a year by Zoom these days, but we offer support to one another. And we have worked diligently under the new Uniform Probate Code. We've tried to help one another. We are here to be, in the future, a resource to you as you deal with probate legislation. Otherwise, we do not participate because we are judges and we try to keep our distance and make sure that everything is done appropriately. Many of the things that happen in our court are done informally, and you'll be hearing from the registers next, and you will find that they are the true workhorses of all the county probate work, and we are extraordinarily proud and honored to work with them. One thing that the judges did want me to share with you is how pleased we are with how the courts have responded to the challenges of COVID. There is no backlog at any probate court in the county. We've been able to move quickly to visual platforms like Google Meet or Zoom and have kept our cases moving along because it's so important. Because just a brief sentence overview is the probate court really is the voice for people and property who can't speak for themselves, whether you're a minor needing a guardianship or a mentally challenged individual who may need a guardianship, or the property of a deceased in the trust. And we'll talk very briefly about that for you. So as that voice, it's critical that we keep things moving so that people's lives are not put on hold. So with our COVID work, with the extraordinary work of the registers, and the ability of the judges to move quickly to meet the challenges, we are very proud to be a resource to you should you deal with issues of concern. Because I thought it would be more interesting and because I wanted you to see the breadth and challenge of our different judges, I've asked the Vice President of our Assembly, Will Avantaggio, to talk about wills, trusts, and estates to you. After that, Judge Amy Fairclough from Penobscot will speak more succinctly about guardianships. And then, of course, any questions that the committee might have, we will do our best to answer. So, Judge Avantaggio.
Good afternoon, folks. I am William Avantaggio. I'm Judge of Probate in Lincoln County. I was just elected to my second term, so I'm starting that. I believe Wills, Trust, and Estates was a 2-semester class in law school. I've got 3 minutes, so we're going to leave a few things out. When most people think of probate, they think of estates. Our perfect estate for probate court is a self-proved will, properly drafted and executed as the statutes provide for them, and unchallenged by anybody. And that estate, we as judges never see. It's approved informally by the registers. The personal representative or executor does his or her job. It comes back in, but again, we never see it. If issues do arrive, and there are many at the intersection of family and money, but whether it be because somebody didn't have a will, or the will is being challenged, or the will wasn't properly executed, or some people like to make changes on them without going back to their attorney's office, then that becomes a formal probate matter, and all of that comes through us, whether it's at the request of a party or by necessity, by practice of law. And those get more interesting. The challenges that can come before us, the issues of personality often is what drives it, but the issues of law and procedure are where we do a lot of our work in this area. And then trusts, perhaps brought by concerns of beneficiaries who are disagreeing with the way that a trust may be being administered, that they're not getting what they're supposed to or as much as they're supposed to, or sometimes a trust has been established at some point by a well-intentioned person that just doesn't work anymore. I had a trust before me recently that was established well in the past in a local town by a resident who had asked as part of it for money to be set aside and used for widows and orphans of Norwegian descent in that town. And there just weren't any. The state of Maine has long since done away with the problem of orphans called that, and the Norwegian population of that town wasn't well identified anymore. And so there were funds being assembled that the town couldn't use for some beneficial charitable purpose. And so the other beneficiaries and the town had gotten together and presented a modification of this trust so that these funds could be used for some purpose like what they were intended. So that's Will's Trust and Estates in 3 minutes, folks. If you have any questions, I'm happy to take some.
That's pretty impressive. Let's pause a moment and see if there are questions for you or for Judge Mitchell. Any committee members have questions at this point? Not seeing any raised hands. Okay, let's keep moving forward. Thanks.
All right. Thank you all for your time.
And just a reminder, we are here to be a resource as you grapple with future legislation that concerns any of these topics. Judge Faircloth is going to take you into another challenging topic.
Yes, thank you, Judge Mitchell. Thank you, Senator Carney and Representative Harnett, for welcoming us here. A lot of times people don't know what probate courts do. Certainly until I was elected, I wasn't sure exactly what probate court did either. I am in the middle of my first term serving here in Penobscot County. Very much enjoying it, very much enjoying serving the people of Penobscot County. And I want to thank Judge Mitchell for inviting me to speak about guardianships. I find that here in Penobscot County, the bulk of my work as the judge actually is doing guardianship hearings and trials. As Judge Avantaggio told you, judges don't see the bulk of wills, trusts, and estates. Most of those get resolved in some sort of an informal basis, and the registers, as they will tell you soon, handle those matters mainly. I find that the bulk of my work is dealing with guardianships. So the probate code, and in Maine that's in Title 18C, provides for two types of guardianships. One is guardianship over a minor. The other is guardianship over an adult. Now, I think we all know what guardianship referring to. It's referring to somebody who is being given the legal authority to make decisions on behalf of another person. Title 18C, Section 5201 allows for the appointment of guardians of minors, and Section 5-301 allows for the appointment of guardians for adults. Both sets of statutes provide the criteria for what needs to be proved by the petitioner in order to be appointed guardian. Both statutes require that those petitioners prove their case by clear and convincing evidence. Now, that's a pretty high burden. The only burden that's higher than clear and convincing evidence is the criminal burden of beyond a reasonable doubt. So in order for somebody to be appointed guardian of a minor or an adult, they have to make their case in a pretty strong way, and that is by clear and convincing evidence. So how does this come up? So the minor guardianships come up, I find, generally in a couple of ways. Parents might be deceased. Parents might have mental health issues. Parents might be incarcerated or otherwise unavailable, perhaps living in a foreign country or some sort of thing like that. Parents might be experiencing substance abuse and unable to parent. So some concerned person in that child's life might come to court and request that he or she be able to make decisions as a parent would on behalf of that child. With respect to adults, I find that the situation usually comes up mainly in two ways. First off, you have a situation where a child is turning 18 As you know, 18 is the age of majority. When a child reaches the age of 18, they get to make their own decisions for themselves. Well, sometimes you have children, almost 18-year-olds, who are unable to do that, specifically developmental disabilities, such as autism. And so I have a lot of parents coming in seeking to be guardians of their child who is turning into an adult. The other way that the adult guardianship comes into play is folks with dementia, folks who may experience strokes. Some of those stroke might be a more temporary basis than dementia, but there are several, sort of medical reasons that people are unable to make decisions for themselves. So a petitioner might come into court seeking to be a guardian of either an adult or a minor in their life. If it's an adult guardianship, the court will appoint a visitor. And a visitor is a person who will go out and, go and visit with the adult who the guardianship is being sought, and will explain the process to them. Now, people are always saying to me, well, my dad, he's 90, he's not going to understand what you're saying, he doesn't remember anything, etc. And I explain that, well, our visitors trained, they're experienced, and they're going to do the best that they can. The visitors then provide a report to the court. If it appears that the respondent, the person who is being sought a guardianship over, requires a lawyer, then the court will appoint a lawyer on behalf of that adult. Ultimately, either the parties will reach an agreement and a guardianship will be appointed, or we end up having a hearing, and in which case the judge will decide whether those petitioners have met the burden required of them for an adult guardianship. The minor guardianship is pretty similar. You have some, as I said, some concerned adult comes in and asks to be appointed guardian of the minor. Now, parents can consent to this. Parents, as you are aware, have a constitutional right to parent their children. We may not agree with how they're parenting that child, but so long as they are fit to parent, they have this constitutional right to do so. So the petitioners need to come in and prove that the parents are unfit if the parents haven't consented. If the court finds that the parents are unfit, then this other person will be appointed as guardian of the child. There are provisions, I suspect my time is running out. There are provisions for emergency guardianships. They can last up to 60 days in both situations. And with respect to the minors, there can be an interim guardianship, which can last up to 6 months. So that I find to be the bulk of my work here at probate court, and I'm pleased to answer any questions that you may have.
Thank you very much. Members of the committee, does anyone have questions for Judge Fairclough? Representative Babbage, go ahead.
Thank you, Madam Chair. Just a quick one. Emergency guardianships and interim guardianships. On a regular guardianship, is there a review or is that a permanent designation?
So in one sense, they're permanent, meaning there's no automatic termination. But in both instances, it can be brought back to court. So there is provisions in both statutes for a termination of the guardianship. So parents can seek to terminate the guardianship of their minor child. They can say, I've been to rehab, I can parent my child now. Or an adult can come to court and claim the same thing. I no longer need the guardianship, and it can be terminated.
And I would just like to add, I take review of the guardianships, as do all the judges, very seriously, and I read the annual required report. As a matter of fact, I'm scheduling today a show cause hearing because I've not heard back from a guardian who was to turn in a report. I don't know what's happened to those children without that report. So we are very strict about that. We learn sometimes that the children have moved to another state, but if we didn't have those regular reports, we would not know. And so that's very important. So once a guardianship is deemed to be temporary, and in most cases we hope it is, that's what it is. But you also know that we do termination of parental rights and step parent adoptions. And that's a very serious thing too. So just so you know, we have the same statutory requirements, the same rules of court, the same rules of evidence. Any of our hearings, any of our decisions can be appealed to the law court. So we are judges in every sense of the word and take that responsibility very seriously. And I do appreciate that question because sometimes reading those annual reports is quite a challenge to get through. Some of them are very thick, they're very old, and you try to find out what is the progress of this person. And so sometimes it's happy endings and you can find a better solution, and sometimes it isn't.
Thank you, Judge Mitchell. I didn't fail to mention that we do have a review requirement where every year the guardian is to file an annual report with us. And I, as Judge Mitchell said, I also review them and take them very seriously.
I know.
Do other committee members have questions? I am not seeing any hands up. Do you have other speakers to present?
Well, I did ask Judge Crockett, who was once a distinguished member of this committee, to play cleanup to see if I had left anything out, because he has a good ear for what a committee needs to know. So if it's okay with the chairs, I would ask Judge Crockett if he has anything to add.
Yes, thank you. Go ahead, Judge Crockett. We are having a hard time hearing you. You're very, very faint.
Okay, any better?
That is a little better. Go ahead. Nope, we can't hear you. I don't know if there might be something on covering your speaker, your microphone.
No.
Nope.
Well,
if he tries to turn off his video, he might have.
Yeah.
What I'm sure the legislature is learning, and I know the court's learning too, that we sure need better broadband connection.
Yes.
So we're ending on a musical note.
Thank you. So let's try one more time. We have a lot of interference at this point.
I am sure Judge Crockett will submit any written materials to the committee. I am very sorry. Again, we do appreciate the opportunity to present to you today. Thank you.
Thank you very much. And we're a couple minutes ahead of schedule, but I think our next group is here. So we'll move on to the probate registers and Register Kathleen Ayers. And I would just ask for folks who are done presenting, if you can log off and switch over to the YouTube channel. That makes it easier for us to admit folks who have presentations coming up. We're having some
I'm here.
more technical difficulties.
This is Kathleen Ayers. Can you hear me?
Now we can, actually. That's very clear. Go ahead. There seems to be some background noise that we're having a hard time identifying, but why don't you go ahead and everybody else can just triple check and make sure.
This is Judge Dunlevy from Mercer County, the probate.
Hi. Well, I'm Kathleen Ayers, and I'm from West Gardner, and I'm the register.
Right. is everybody, can you just wave your hand if you're unable to hear Kathleen Ayers?
Okay.
Now we can hear you. It's funny, sometimes there is a really significant interference, but go ahead and let's give it a shot.
Sure. Well, thank you for your patience, Senator Carney and Representative Harnett and the Judiciary Committee. I really appreciate this opportunity to speak to you. I'm the president of the Maine Association of Registers of Probate, and I've been the chair of the legislative committee for longer than I would like to admit. I submitted a page of all the things that probate court does, and I will go over just a little bit of that, but I wanted to talk about a little bit our association. Our association is a group of Republicans, Democrats, big counties, small counties, and we have managed to be united in a lot of ways. And one of those ways was our mainprobate.net website. And so I want everyone to remember that mainprobate.net website. That is something that we collaborated together to get a unified docket system and be able to sell our forms online. And it is morphed into imaging and electronic filing. And that is pretty amazing for a county group to agree on anything and to be able to get funds from each board of commissioners and each budget committee to get that done. And I would just want to toot our own horn for that once again. The judges went over the informal formal process, which I was going to go over a little bit about how we do the informal estates and process them because they're perfect and they don't need any judicial intervention when it starts. They may when it finishes, but the non-probate, I want to talk about the non-probate for a minute. There are a lot of people in this state who die with nothing but a car, but a small bank account. And we're the entity that they call to find out what to do. We don't collect a fee for that. We don't have a proceeding for that. But trust me when I say that takes up a lot of our time. It is a public service that people very much appreciate. And I just want to say that is a lot of our time. The registrars also run the scheduling, the court. We have a lot, you have a lot of bills coming your way that involve probate, and I see at least 12. So it will be good to know things like the priority statute. There's some domestic partner issues with that coming. Also, in the guardianship world, COVID-19, I'm just looking at this list of mine. COVID-19 has been such a challenge for us to get our visitors into hospitals, to get people out of hospitals, to get mentally ill people where they belong, and they get stuck in hospitals. And you'll be hearing a bill about that too down the road. But I got to give props to, we're now friends with nurse managers and social workers, because the new code says that we have to, the person who's going under guardianship has to come to court, or they have to be there electronically or be excused for reasons. And that has been a big hurdle in the beginning, We still don't have places and placement for a lot of our elderly, mentally ill people. That's a huge hurdle that we get involved, the court gets involved, but there's no place for them to go. And so we've been open. Some of our buildings have been closed, and we've been doing by appointment only, which is working out okay. We've done Zoom, we have to do Zoom hearings. Our adoption consents, we've been doing some by Zoom hearing, because we need to keep that going too, because we also do agency adoptions and private adoptions. So we don't want to leave a new baby in limbo. So these are the challenges that we've had in COVID. I know I'm really talking fast, but I'm trying to cram it all in. And I also, of course, want to remind everybody that there's bills about attorneys for guardianship, people going under guardianship. We're very vigilant about getting people attorneys for anything, any limitation that they want. If they have any concern, if there's any concern, if there's refusal of medication, for instance, that's an issue. They're going to get an attorney up front. And the people who pay for the attorney are property taxpayers. So mainly we have fees. It does not cover even not even a half of what we cost, of course. But that is an issue too. And I want everyone to remind everyone that it is property taxpayers. We do have county commissioners that are our board, and we also have municipal committees that are also elected people, budget committees, that the commissioners and myself have to present budgets and get those through. So I've talked a lot now. I did forget a couple of things on my sheet because I knew I would. There's just so many things that we do. But adult adoptions is one that I did not put on this sheet, and we do quite a few of those. Usually somebody has raised a person their whole lives, and then when they get older, they want them to be adopted by them. So that is the usual situation with those. And then one other thing is we have new confidentiality laws that are causing some little conflicts. And one of the things that we do also is concealed weapon permits, where people don't understand the depth of the things that we do, I don't think. The police departments, if someone wants a concealed weapon permit, they have to come to us and get a sheet saying that they're not under guardianship. So those are just a few of the things that we do on here. And I did note on my sheet about paralegals, the complexity of the issues that are coming our way. The judges do need more help. They do need more help. And only a few of the counties right now have paralegals. Mine is one of them. But especially courts that have state institutions like Riverview, like Dorothy Dix, and for myself, like Togus. The complexity there, it's just a regular clerk, a person off the street. It's not working anymore. We need in-depth help, and we're working towards that. So I'll stop rambling now. Does anyone have any questions?
Yeah. Does any member of the committee have questions for Ms. Ayers? Not seeing any hands up, but I actually have one for you. Having spent a little time practicing in probate court, but not much, I did not appreciate the extent of the services that the registers perform. And I'm just wondering if you can tell us a little bit about accessibility and how accessible your offices are to people, based on geography. For example, is there just one in each county? Is it difficult for people to get to your office to get services? And are there steps that you've taken, not in pandemic times, but just overall to make sure that you're able to serve people, particularly in more rural areas?
Well, there is just one court in each county. I'm not sure that before pandemic times, I think we were more accessible than most courts. But now I think things will change. I mean, I am a hugger. So let me say that this is a hard time for me, but when people come to our office, we didn't have shields. We didn't have shields. Now we do have a shield. We had a place for them to sit so that they could fill out paperwork. And in COVID times, that's really not working either because of the spatial issues. So we do have some spatial issues in the older, smaller, narrower hall courtways. but we all should be ADA. We all should be compliant for wheelchairs and accessible in that way. But we are in some very old court buildings, and that is sometimes can be a barrier. Right now in this time, it can be. But as far as taking the time with people, taking the time with pro se people in my area is very important, because a lot of times these are estates and things that not only can they not afford a lawyer, but a lawyer probably wouldn't want to take it. We can't, it's not a money driven thing that you'd want to pay for an attorney. So we walk that fine line. We try not to give legal advice, but we will sell you the form, and we'll help you fill it out, and we'll help you notarize it and tell you where to go with it. I'm thinking of the affidavit of collected personal property when I say that. But I think we try to be really patient with people, and I hope that comes across.
In my limited experience, it has come across, and I do appreciate it. And I think we all as a committee get a flavor of the fact that you're dealing often with people in really difficult circumstances and with a lot of compassion. Yeah. Thank you. Are there other questions by committee members? Representative Babbage?
Yes, thank you, Madam Chair. Good to see you, Kathleen, again. Judge Ayers.
No.
Sorry about that. Forgot.
I'm sitting in her chair, though.
Yes. Madam Registrar. What I wanted to ask is regarding Dick's and
somebody needs to mute Judge Dunleavy.
I was wondering about the institutions you mentioned, Togus and Dick's and Riverview, and if you might just share, is it a jurisdictional thing? Is it getting people in and out?
It is getting people in and out.
There are problems I've heard apparently throughout the East Coast with internet connectivity, and I think we're hearing some of that. Let's continue to try to move forward. And
I just wanted, if I could, Madam Chair, to ask her if COVID had any impact on that institutional relationship.
Yeah, it's harder to get people out of the institutions in the COVID situation, but the change in the law, in the committal law, and that guardians can now force medication in these institutions has made a push for guardians.
Thank you.
Other questions by committee members? Not seeing any. All right, thank you very much. Is that the conclusion of the probate register presentation?
I think I will yield my time.
Wonderful. Thank you for coming to present to us today.
Thank you.
So we have one more presentation before we head into a 15-minute break, and that presentation is the Department of Corrections. So let's go ahead, and I will just call on Commissioner Liberty to start us off. Thank you very much.
Hi, it's Anna Black. But while Commissioner is just logging on here, just want to introduce ourselves. So my name is Anna Black. I oversee government affairs for the Department of Corrections. And just before we get started, I just want to give you a quick overview of how we were planning to do this. First, as you can see on your screen, speaking today is Commissioner Liberty. Deputy Commissioner Ryan Thornell is also on, and our Associate Commissioner of Juvenile Services, Colin O'Neill, will speak as well. Commissioner Liberty is going to start. He'll give a quick overview of the department, followed by Associate Commissioner O'Neill, who will discuss Division of Juvenile Services. followed lastly by Deputy Commissioner Ryan Thornell, who will talk a little bit more extensively in a short time frame on the MDOC's response to COVID-19. So we recognize that we have just a short time with you, but we want to make sure that you have time to ask questions. So feel free, if you prefer, to ask questions in the middle. We're all comfortable with that. While we don't have a lot of time to go into great detail about the department, you should all have received the DOC's guide for state legislators. If not, we can make sure we get you another copy, but please feel free to take some time to look through that. And if you have questions based on what you read or what you hear today, feel free to follow up with me and we'll make sure we get you whatever else you need. So with that, I will pass it along to Commissioner Liberty.
Good afternoon, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. It's a pleasure to be here with you, and it's a pleasure to serve as your Commissioner of the Maine Department of Corrections. I'm fortunate to work with an outstanding team here, both leaders and the individuals that stand the line, both in the community and in the facilities. I've enjoyed working with several of you in criminal justice and other matters last session, and my heart goes out to you because I know it's very difficult being out of session last spring and trying to do the advocacy work that you had to do, and you worked with your constituents, and I applaud you for all the work that you did during that time. I know it wasn't easy. The Maine Department of Corrections manages and difficult scenarios and situations, and some of the most difficult Mainers in our state. Many of them have mental illness, substance use disorder, post-traumatic stress, sexual assault, and have had many adverse childhood experiences which result in their incarceration. We recognize that, and it's our mission to reduce recidivism by identifying just exactly what brought them to corrections and then get to work and helping them resolve those issues. And obviously you're aware that we've been focusing very heavily on substance use disorder with MAT, and there'll be some discussion about that on the light here. And working with our youth, you've heard a lot of work about the work that we've done at Long Creek with the Juvenile Justice Task Force work we did, and some of you were involved in that. So we're going to give you an overview of that today. The major issues that we dealt with obviously this year related to COVID, and we'll have a detailed explanation of just exactly how we took that on. A lot of discussion early on. What do we do with our residents that are incarcerated, and how do we manage that population? How do we keep our employees safe? And Dr. Ryan Thornell will speak to that. It's really only through the dedication and sacrifice and professionalism of the officers that are standing the line every day working in our correctional facilities. We've had a significant decline in population due to many factors during COVID in 2020. The judiciary, the law enforcement leadership, patrolmen, the district attorney's office all worked hand in hand with the jails and the Maine Department of Corrections to keep the population down, only incarcerating those that had to be incarcerated. But obviously we do know that there's a tidal wave of unsentenced Mainers, untried Mainers, and we're anticipating that number to swell as time goes on. To give you an example, in custody in 2019, our adult males, we had 2,015 in our custody, and we had 190 adult females. This December, we had 1,588 males and 427 reduction in a male population at the Maine Department of Corrections. Over the last 2 years, since 2018, we've had a 50% reduction in adult female residents in our care. So there's been a reduction in part to COVID, in large part to the work that we're doing in these facilities, dealing with substance use disorder and mental illness, I believe. Our facilities, for those of you that aren't aware, we have 6 correctional facilities, and they are the Maine State Prison, which is located in Warren. We have our maximum security male offenders there, and those residents there normally, if they have more than a 5-year sentence. We have the Maine Correctional Center, which, as many of you know, it's in Wyndham, and we have individuals there less than 5 years, generally speaking. That also serves as our reception for both males and females in our system. The Women's Center is also located in Wyndham. It's a subsect of MCC, and that's where our medium and maximum adult females are housed. The Southern Maine Women's Reentry Center is a real gem of our system. It is also located in Wyndham, and that's where we have our minimum security female residents. They're located there. They do a whole lot of programming, which is very successful, and they also do work release. Mountain View Correctional Facility has just males, medium, and minimums. We do a lot of programming, and we also do work release from there. Those are our 2 work release sites, one in Wyndham at the Women's Reentry Center, one in Baltic, and the second adult one is at the Baltic Correctional Facility, also located in Warren, adjacent to the main state prison. With the last one is Long Creek Youth Development Center, and that's where we house our youth. And a lot of media surrounding that last year, a lot of work. One of our primary goals is to reduce our reliance on incarceration for youth and use restorative practices and diversion and find other options to find that balance between public safety and providing the programming for the youth that are sentenced to us. The Maine Department of Corrections has focused on in the last year and continue to focus on the wellness of our employees. Corrections can be a very difficult, trying career, and it's important for us to ensure that we take care of their emotional and physical wellness. We've been working on that pretty extensively. We have 3 significant construction projects that are ongoing at this time. The largest of which is a $141 million construction project that's occurring at the Maine Correctional Center. That's been ongoing for a couple of years, and we expect that to be completed in June of 2022. The second project was the Down East Correctional Facility, and as you remember, under the last administration, the Down East Correctional Facility in Machiasport was closed, and we worked with the members of the legislature and the governor's office to establish a construction project there. It's about an $8 million project. We'll have 50 residents and 15 staff there by August of this summer. The Maine State Prison is the last construction project that we're working on. That particular project is a collaboration with the Doris Buffett Foundation. They granted us $800,000 to create 2 additional classrooms, smart classrooms, which will greatly enhance our efforts with the University of Maine at Augusta that has been working with us for more than a decade and causing creating a significant reduction in recidivism. In the interest of time, I'll now turn the mic over to Colin O'Neill. He's an associate commissioner in charge of juvenile services. Colin?
Thank you, Commissioner, and good afternoon, Senator Carney, Representative Hartnett, and distinguished members of the Judiciary Committee. My name is Colin O'Neill. I'm the Associate Commissioner for the Juvenile Division. And I also want to introduce Sonia Morris, who's also on this call. She is my right hand and my coordinator for data and contracts. I am the Associate Commissioner in charge of the Juvenile Division, and the division is made up of 2 parts. One is field services, which houses probation and probation offices. There's 3 regions in the state. And the other part of the division is Long Creek Youth Development Center. As the commissioner says, that's where we house committed and detained youth, both boys and girls in South Portland. The Juvenile Division is committed to the result that all Maine youth successfully transition into adulthood. The division's contribution to this result is that justice-involved youth experience a fair, equitable, and responsive system, and that leaves them with positive youth outcomes. We recently have been also committed to the reduction of institutional secure confinement, and by really increasing our use of community program and supports to reduce the amount of youth in secure confinement. So what I'd like to do is to share with you the numbers in the Juvenile Division. I think it will give you a good snapshot as to what we're working with. And in 2020, we've seen the lowest numbers in recorded history of youth entering the juvenile justice system. In 2020, 1,742 youth were referred to the department. Out of that youth, 140 were detained, and only 14 youth were committed. So as the commissioner identified earlier, the reduction of our population That translated in a 34% reduction in commitments and a 69% reduction in detentions. And so overall, we saw a little over 50% reduction of youth in secure confinement. Currently, there are 30 youth at Long Creek, 20 committed and 10 detained. So those are the lowest numbers that we have ever seen. Some of the highlights of 2020, the commissioner referred to the Juvenile Justice Task Force. And last year, a task force was convened, and also a consultant was hired to do a statewide assessment of the juvenile justice system. The Children's Law and Policy Center was that consultant that was hired to do that. And at the end of spring, they released an assessment with a little over 50 recommendations for short, medium, and long-term recommendations for the system. I want to kind of identify a few highlights in the sense of what we were able to accomplish in the last 11 months, based primarily on those recommendations from the Children's Law and Policy Center. One of the major accomplishments we were able to do is open up a staff secure residence for girls. It's called the STEPS program. It's outside of Long Creek, and it is not a secure program, but a staff secure program. So that means there's no locked doors. The girls that are in there now, or all the committed girls, have been moved into that residence. So that's a major accomplishment. And again, it's our work to try to create alternatives to secure confinement to reduce the use of secure confinement and the number of kids that are at Long Creek. We also hired a credible messenger program. And so we researched and looked at how we can better serve youth of color that are in our system. And the credible messenger program, there's a very successful program in New York City. And we sent a team of folks down to New York to look at that program and modeled our program in Maine out of that program. We hired a full-time credible messenger coordinator who is developing a credible messenger program right now in Lewiston and is looking to increase that to statewide in the next year or two. Another addition that we had this year was to add more beds out in the community for youth who are at risk for being detained at Long Creek. And so we increased our contract with New Beginnings to provide us with a few more beds in intended care. And so those are youth that are at risk for being detained, but could be managed in the community in a supervised setting for a short period of time. Another accomplishment that we are pretty proud of is that we've developed 3 regional care teams throughout the state in our respective regional in our respective regions. These care teams are private and public stakeholders to review high needs youth to increase access to community programming and to prevent secure confinement. Each team was provided with flex funds that was provided with us by the Juvenile Justice Advisory Group. And so they review deep end cases of youth that are primarily in multi-systems. So those are kids that are being served by Department of Health and Human Services and labor and DOC. And so these are teams that meet monthly, and they review what those kids need in order to stay out of the deep end of our system. And so those teams have been meeting since July. And the other purpose of those teams is to provide information and data that will then be given on to the Children's Cabinet to be looking at bigger system agenda items. So moving on to initiatives for 2021. One of the things that we want to do is to also add a home for boys, a staff secure home for boys, to again further the reduction of the use of secure confinement and lower the head count at Long Creek. We're looking to open up a boys' home so boys can transition out of Long Creek and be in a non-institutional setting. So it's going to be very similar to the girls program. And we are actively looking for residents that we can lease in the greater Portland area to give us that additional resource. Another thing that we are looking to do is to increase our restorative justice capacity in Maine. I'm looking to partner up with the Department of Education. And so we are looking to hire a restorative justice coordinator that will help train school personnel in school systems that want to start to develop restorative programming within their schools, K to 12. And also this coordinator would train DOC staff as well to use a more restorative justice lens in their intake and case management practices. So we're looking to hire that coordinator sometime this spring and summer. And lastly, one of the things we were able to do and we're looking to do is we got a grant with the Gorman Foundation and from the JJAG to hire a youth and family outreach coordinator in the greater Lewiston area. We're looking to try to identify youth of color and families of color to be able to prevent them from entering and penetrating the deep end of the juvenile justice system by outreaching to them early on when they're just starting to bump into our system and provide them with more culturally competent programming so they can stay out of the deep end of our system. So those are just a few of the highlights that we've been able to accomplish this year. It's been a very challenging year, as the commissioner pointed out, with COVID and trying to follow through with some of the recommendations of the Children's Law and Policy Center. And we feel really good about that. The numbers that we're seeing, the reduction, are not just COVID related, that they also are a reflection of the increase of our programming out in the community and the beds. So we were looking to continue to make sure that those numbers stay low in the near and distant future. So I'll end there, and we can move on to the Deputy Director Thornell.
Before we do that, could I just ask you a couple of language questions to clarify? Could you please explain to us what the Credible Messenger program is? And then also for the benefit of some committee members who may be new to the subject matter, the difference between committed and detained, so that we have just a little bit more background information. Thank you.
Sure. Thanks for asking. The Credible Messenger program is really a program that identifies credible messengers who are folks who have been in the system, who are system involved, young adults or adults, to help mentor those young people who are currently in the system or who are at risk of entering the justice system. And so the credible part is that these are people who have been in the system, who have been in the shoes of the young people that we are now starting to see. And they are, through meeting with them weekly, mentoring them and helping to keep them out of the deep end of our system by role modeling and developing a connection. And so it's been shown in many other states to really reduce the amount of, especially youth of color, from entering into the juvenile justice system. And the difference between detained and committed is a great question. Detained youth are typically non-adjudicated youth. Those are youth that are being charged and have been arrested for serious crimes. They have been detained either by Department of Corrections staff or by an ADA or DA or judge to be held prior to either their first appearance in court or by another appearance in court down the road to review disposition. Committed youth have been adjudicated and the disposition has been a commitment, usually to last to the 18th, 19th, 20, or 21st birthday of the juvenile.
Thank you for clarifying. Representative Harnett, did you have a question?
I did. Thank you, Madam Chair. Thank you for asking the question about the difference between detainees and folks that have been committed. And I applaud you on the really significant reduction in the number of youth who are detained. It's really a staggering decrease. My question has to do with cost, and I don't want to diminish the human cost to a youth who is placed in a secure setting, basically incarcerated. But I'm wondering how much is spent on having a youth detained at Long Creek as opposed to having a youth remain in a community setting? And what are the differences in the outcomes between those two settings?
It's a great question as well, and I can't get you an exact figure, but I can definitely say it is a lot more expensive to detain a youth in Long Creek than to house them even in a shorter term residence using a kind of a contracted agency, or to wrap them up as tight as you can using some type of home-based treatment intervention. And so, you know, that's my short answer, in the sense that it's a lot more expensive to have them in the deepest end of our system compared to trying to keep them out into the community.
And what about in terms of outcomes? How do youth fare being in the community as opposed to being incarcerated?
Well, you know, in general, you know, we try to keep kids out in the community as safely as possible. Outcomes are much better if you can keep a young person closer to their family, closer to their the resources, their school, their work, and staying connected. And as safely as you can do that, the outcomes are better because you don't sever those ties by putting them in a correctional facility, where sometimes you have to kind of restart everything. And so we really work hard to try to keep kids as safely as possible in the community, and not severing those ties.
Thank you. Thank you very much.
Before we move on to the next speaker, does any other member of the committee have questions for Mr. O'Neill? Not seeing any hands. All right. Thank you very much, Mr. O'Neill.
Thank you.
All right. Good afternoon, Senator Carney and Representative Harnett and distinguished members of the Judiciary Committee. My name is Ryan Thornell, and as Anna mentioned, I have the privilege of serving as the Deputy Commissioner for the Department of Corrections. In my primary role, I oversee the day-to-day operations of the department, and am largely responsible for ensuring Commissioner Liberty's vision and priorities are carried out across the various divisions. One aspect of that has been the oversight and management of our plan in response to the COVID-19 pandemic. And so I want to just spend only a few minutes. I want to be respectful of your time, but I want to spend just a few minutes to brief you on the department's response to COVID-19 and where things stand as we move forward into 2021, and certainly answer any questions. The Maine DOC benefited very early on from a strong collaboration with the Maine CDC in the early days of COVID-19 discussions here in Maine, well before a COVID-19 case ever made it into our Maine communities. We were at the table with Dr. Shaw and his Maine CDC team, getting briefings from him and learning about what COVID-19 was at that time and the potential ramifications for it as we moved later into 2020. And that collaboration with the Maine CDC has continued through current. Every single day we are in meetings with Dr. Shaw and his team, learning about the latest news and updates and response protocols to COVID-19. And that has helped us tremendously arrive at a place where what I hope you'll hear and agree with is some effective outcomes during a very difficult time for the world. And some of the early planning and preparation and decisive actions that we took significantly impacted our facilities in good ways because it kept our staff and residents safe. We implemented enhanced staff screening protocols in early March in conjunction with the closure of our facilities to the public. So we shut down visitation. and offered alternative communication strategies and use of technology to stay in touch with loved ones. We closed down the doors to volunteers and other members of the public from a public health perspective. We implemented enhanced sanitation protocols, and very early on, we implemented the use of PPE, much of which we made internally, which I'll speak about here in a few moments. We implemented very stringent quarantine protocols in order to ensure safety of our residents and have appropriate medical attention to our residents as necessary. And we also took measures at various times through 2020 to pause county jail intakes coming into the Maine Department of Corrections in order to prevent any potential exposure from the county jails. And that went well through strong partnership with the Maine Sheriff's Association and collaboration with them that still remains today. And so we are very fluidly speaking with county jails as they have cases and things, able to suspend intakes from them as we go forward. Another step that was taken across the year and continues into 2021 is we've benefited from the full use of our supervised community confinement program. And what the SCCP program is, which you may hear more about during this session, is it is a release program that is an extension of our community custody work release facilities. Commissioner Liberty mentioned we have several of those, including Bolduc, Mountain View, and the Southern Maine Women's Reentry Center. And the adult residents in those facilities are able to earn a placement in the community up to 18 months prior to their scheduled release date and secure a residence in the community for that transition. And in 2020, we placed 168 men and women into that program in the community, releasing them into the community early. In comparison to 2019, we only released 67. So that's an increase of 101 releases into that program during 2020, which allowed us to utilize more space within our facilities for other public health reasons. Additionally, what benefited us, Commissioner Liberty mentioned, our population on the adult side is at a 10-year low. And so we were able to utilize different areas in our facility for quarantine purposes, medical purposes, and other preventive measures. And finally, we benefited from and continue to benefit from a very robust testing plan for COVID-19. Many do not know this, are not aware of this, but the Maine CDC actually requested that our department utilize some of the very early rapid antigen tests available in the state of Maine on our population. And we actually helped them develop protocols and policies for those test use out in the community based upon our experiences. And so to date, we've tested over 7,000 residents, conducted over 7,000 tests on residents in our facilities, and conducted over 4,000 tests on our staff over the last year. And so when you think about only having, as Associate Commissioner O'Neill mentioned, only having roughly 30 to 35 juveniles and only having approximately 1,800 adults, conducting that many tests is significant to identify COVID-19. To date, as a result of those tests, we have had 157 adult resident cases in our facilities. And in our juvenile facility, we've had only one resident case during this entire pandemic. And in our staff, we have had approximately 65 staff cases. So all totaled, we are just above 200 total cases, staff and residents, during the entire pandemic. And I want to put that just real briefly in context. I want to just mention there's the Marshall Project tracks this information nationally for all 50 state departments of corrections in order to see how COVID-19 is impacting incarcerated men and women. And to date, over 350,000 cases of COVID-19 have been in departments of corrections across the country, 157 of those in Maine. And that puts us at the very top or bottom, depending on how you look at it, in terms of infection rate and case rate for departments of corrections across the country. And in many comparisons, our Department of Corrections facilities are safer from an infection rate perspective than most communities outside of the state of Maine. And so I want to just mention that because I think that highlights the clean, safe, and healthy response the department has taken. I also just want to briefly mention some very strong partnerships that have been born out of the COVID-19 pandemic. First and foremost, that with Maine CDC, which I already mentioned, but also with the Maine County jails. Oftentimes, the state DOC and the county jails are not always mentioned in the same sentence together. But we have taken this opportunity to really bridge that communications with the Maine Sheriff's Association and their jail administrators, which includes collaboration daily on COVID-19 calls across our incident command teams, sharing of lessons learned, conducting training and reviews for the county jails, and providing them with PPE made by the Department of Corrections. We've also provided staffing support to the Department of Labor.
I'm sorry to interrupt you, but we're a little bit over time, and I did want to ask committee members if they had any questions for you. So if you have another sentence you wanted to give us, and then we'll have a few questions, or we can break questions right now.
Absolutely. The only other thing I want to mention, it might stave off a question, is we are moving into our vaccination protocols. And so we are in the middle of rolling out vaccines to our frontline essential staff in our facilities. And after this week, we should have approximately 50% of our frontline essential staff vaccinated with their first dose of the COVID-19 vaccine.
All right. Thank you very much for the information. Committee members, I'm going to open it up for questions. And remember, just raise your hands where I can see it. Representative Babbage?
This could be a numbers question. I just wanted to know that 65 staff that have become infected, can you give us an idea of the total numbers of staffers, staff people that you have on board, to give us an idea of what percentage that might be? And also just overall, given the ups and downs of COVID, we're kind of in a surge, nationally even right now. Where do we stand with active cases? Thanks.
Absolutely. Great questions. Thank you. So in terms of the number of staff at the Department of Corrections, we have approximately 1,300 staff across the department, of which around 1,100 of them are actively working in our facilities. And then in terms of active cases right now, I'm pleased to report we have less than 5 active cases in staff and residents across our facilities. In fact, right now, I believe the only active cases we have to date are in staff members that are out, largely from community exposure at schools. We do not have active resident cases at this time.
Thank you. Representative Harnett, did you have a question?
Thank you, Madam Chair. And this is a question for Commissioner Liberty. I want to make sure I heard you correctly. Did you say that you have an expenditure of $141 million coming up in Wyndham, or did I mishear that?
That money has been appropriated, and I'm not asking for 141 million in this fiscal environment. It's an ongoing project. The money's been appropriated.
Okay, the reason I asked the question is, as we see the population going down of incarcerated people, what are those dollars being spent on?
So if any of you have been in the Maine Correctional Center, there are many parts of the facility that's very Shawshank-like and very outdated, and it made it difficult to deliver effective services. And so the work that's happening there is to enhance classrooms, to enhance some of the dorms that were very outdated and needed to be replaced. So there were no increase in bed space. It's just an updating and a modernization of that facility.
Thank you.
Other committee members with questions? Not seeing any hands. A little while ago, our committee member David Hagan joined us, and I'd like to give him an opportunity to introduce himself.
Thank you very much, Madam Chair. I am David Hagan. I represent House District 101, Hamden and Newburgh. Glad to be here.
Thank you. And at this point, we're going to take a break until excuse me, 2:40. And I would just let committee members and anybody else who's on the Zoom know that this will continue to stream on YouTube. So please turn off your screens and make sure that you're muted before you step away from your computers. And thank you very much to the Department of Corrections for appearing here today.
Thank you for having us.
Good afternoon, Dean Softly.
Good afternoon, Senator. How are you?
I'm good. How are you doing?
I am great. You know, the old saying, may you live in interesting times.
Mm-hmm.
And we truly all are.
We're just resuming after a short afternoon break, and I think that committee members will start logging on in just a moment. And we actually have one little piece of business we're going to do right when we start up, which is to do a few more votes that were part of a roll call that was taken earlier today, but that'll just take a moment and then we'll get going.
Great. Thank you so much for inviting me. I really appreciate this.
I'm glad you're here.
Chief Softly, did you get your Mountain Dew?
Here's looking at you. I could not believe it when it arrived. This is just absolutely fabulous. Now I feel ready.
Well, we are definitely going to miss you. So
you guys are the best. I have to tell you, and I'll stop when you're ready to take the vote, but I did get a lecture from the person who delivered it, indicating that this is probably the worst thing that a human being can ingest. But so far, so good.
That's funny.
Senator Sanborn, I would much rather be trying out some of your wonderful products, but getting through the afternoon becomes fairly important. Great to see you.
Understood. There's a time and a place for everything.
Exactly.
All right, committee members, if you haven't turned on your videos, please do so that we can resume. I did want to let you know that we had a roll call vote this morning to re-refer LD 15 to Criminal Justice and Public Safety. And we are going to, many of us were able to participate in that roll call vote. Our clerk, Susan Panette, is going to call those members who are present now who weren't available earlier in our meeting today. And I think everyone who needs to vote is here. So let's go ahead with that. This is the continuation of the roll call vote on LD 15.
Thank you, Senator Carney. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Downs. She's on mute.
Yes.
Representative Downs votes yes. Representative Newell.
Yes.
Representative Newell votes yes. That is 14 members voting in the affirmative. You have just voted on your first bill for the 130th legislature.
One down, 199 plus to go. That's well done, committee. And on that auspicious note, I will introduce Lee Softly, who I knew in my role as an attorney as the Chief Justice of the Maine Supreme Court. And actually, Judge Softly, I think that we even did a trial together in small claims court way back when. It is a wonder to have you here today, and you are now the Dean of the Law School and here to speak with us about the law school. Thanks for joining us.
Thank you so much. Senator Carney, Representative Harnett, members of the Joint Standing Committee on the Judiciary. I am honored to be here this afternoon. The first thing I would do is address nomenclature. So the best thing about having changed jobs is I got my first name back, and I would invite you all to call me Lee. It's just been a delight to have my own name again. And I know that for attorneys that might come hard, but please honor me, that would be great. I am just delighted to be here, and I know you are all on a very short time frame, and I took a look at your schedule for the day, and this is the point at which you say, my head is full. So I'm going to go very fast through a number of things, and I would invite you to stop me if you have questions or send me a chat so I make sure that I'm getting to those things that are most important, because the law school is an amazing place, and this will come as a shock to those of you who know me. I could talk about it for hours. So I'm going to try to summarize the things that are great. I'm hoping you all have something that looks like this, which gives you just a quick overview of a number of things that are going on at the law school. But what I'm going to do this afternoon, I hope to make this as useful to you and as expedited as possible, is to tell you what surprised me when I shifted from one job to another. So my first impressions at the law school, I am embarrassed to tell you, led me to understand that about 50% of what I thought about Maine law was just flat out wrong. And I prided myself on understanding a lot about the Maine judicial community. So let me tell you about the great surprises that I found first when I arrived. The law school had been, as you all know, and you don't need to hear me repeat it, although I will, horribly underfunded, really badly underfunded. And what surprised me when I arrived was how vibrant and exciting this very underfunded institution has been. The faculty and the staff at the law school are so committed to access to justice and to the rule of law that they have gone the extra mile for years. And I'll talk to you a little bit about that in a minute. And the students at the law school, the graduates of the law school, the alumni who still care very much about the law school were even more impressive. That was really heartening to me as I arrived. The programs at the law school, and you've got some of them under the title of Signature Programs of Legal Education, include a clinic that's nationally recognized. It was one of the first real litigation clinics in the country. It does amazing work. It reaches hundreds of people every year. And the students who come through the clinic really are energized by what they're able to learn and to do. The privacy program, which was one of the first of its kind in the country, has now become really the national standard for privacy. And I am excited to tell you, hot off the presses, that there is a moot court privacy competition. It's been held for the third year in a row in Helsinki. This year, this is an international competition. And this year, the only students who got into the competition from the United States were students from Maine law. And yesterday, they came in runners up to the winner of that international competition. I am so proud of them. I cannot tell you. It was just an amazing thing. And it's representative of how exciting things are at this law school right now. Of course, you've read about the Arctic program, which is going to be so important in the years to come. The Rural Justice Program is really getting its feet under it. And we have just a month ago finally gotten ready to launch a fully online compliance certificate for executives in Maine, not necessarily law students. So there's a lot going on that's just really surprising and truly wonderful. The surprise that I wasn't really ready for, though, was how bad it is here and what was lost over the last 6 or 7 years of really terrible restricted budgets. So one of the tragedies is that the Center for Law and Innovation was eliminated several years ago. That program helped new businesses, especially STEM businesses, organize businesses, get financing, get patent applications filed. And Maine law, and at the same time, the university within which it sits, stepped back away from innovation, which has been so critically important to fueling Maine's economy. And that, I think, was a tragedy. We are working to undo the loss of that program. Its shell still exists, and I'm hoping to get resources to bring that along. New clinics have been proposed, and Professor Deirdre Smith, who's done just magic with the clinic, has proposed expanding the number of students who are able to go through the current clinic. None of that has been possible because we have so few faculty at Maine Law. We developed, by we, I mean the wonderful people who were here before me, a Masters of Law program for people who don't need a full JD, but really work in areas where the law and the lawyers they work with would be benefited by them having a master's. That was presented to the university system and was rejected because there weren't sufficient resources. And recently, just as I was arriving, two wonderful professors gave up the ghost, determined that there weren't enough resources, and left Maine, which has left us without a criminal law professor at the University of Maine School of Law. Now, every time I say that, I'm embarrassed. 50% of the work in the courts in this state is criminal law in some form or another, and we do not have a full-time criminal law professor. We also lost our property professor. So I am pushing hard to get a restoration of the funding that will let us get back to foundational issues before we get to the next innovations. So let me just tell you that looking back over how we got to where we are, this is a very long conversation. I'm happy to talk to you about it further if you have questions. Beginning in about 2011, the law school's budget began to be insufficient to keep it going. And over the next 8 years, the system didn't have or wasn't willing to spend the money necessary to keep the law school in a foundational basic form. So there were about 8 years, the last 5 of them very serious, where the law school simply didn't have enough money, and it has been cannibalized. That's how we lost the Center for Innovation. It's how the clinic stayed constricted. It's how we were left in this building. I won't take any of your time to talk about the building, but it has to be replaced. So during that period of time, the law school became more and more constricted. And in 2017 and 2018, people began to realize that it was about to fail. Then the group was put together to look at the future of the Maine Law School. It filed a report. Just as that report was coming in, Chancellor Daniel Malloy was coming into the university system. And the combination of the recommendations in the report and Chancellor Malloy's enthusiasm for having a robust law school in the state of Maine all came together in one beautiful moment where he said to me, if you will come to the law school, I have resources that will help. So I'm going to tell you that that conversation occurred in early February last year. I agreed to come and be dean, great excitement, all kinds of wonderful things on their way. And then we heard the word coronavirus, and nothing has been the same. So we are a little stuck, and we're trying very hard to move forward, notwithstanding being a little stuck. And we've got a really solid plan that we're presenting to the chancellor and to Ryan Lowe. Many of you remember Ryan. He is now shepherding the budget for the university system, and Ryan has been really wonderful to work with. So I'm watching the time. I want to make sure you get answers to your questions, but I'm going to throw some numbers at you so that you will have context for the budget issues we're talking about, because they are not huge. Maine Law's budget is actually very straightforward. It's primarily people. The personal services budget for fiscal year 2021, remembering that we have 2 vacancies in the faculty lines, totaled $6.3 million. All other expenses, that's not what the university calls them, but I've spent too long in state government. So all other expenses totaled just $1 million for the entire law school. So the total costs of running the law school last year, which were not enough but kept the doors open, was $7.3 million. The university receives funding from two sources. So the law school receives funding from two sources. One is tuition and fees, and the other is the university system, which of course receives funding through the general fund. Last year, tuitions received totaled just short of $5 million. That left us with 2.3 million that would come from the system in any other law school that's nested as Maine law is within a university. But the system had only been supporting the law school to each year somewhere between 800,000 and about 1.3 million each year. Far too little to keep the law school going. Last year, we recognized that we had to keep the doors open and that we had to keep paying people. And I am happy to tell you that the chancellor, the board, Ryan Lowe, all worked together and stepped up so that the law school received 2.3 million from the system, augmenting tuition, and we were able to close the budget at the end of the year. Just to put this in context, though, the University of New Hampshire, you may recognize, UNH Law School used to be Franklin Pierce. It became, like Maine law, law school nested within UNH because it could not survive independently. UNH provided the law school, the University of New Hampshire Law School, approximately $6 million each year over the last several years to run the law school. UNH is about the same size as Maine law. So while Maine law was receiving somewhere around $1 million, a little up or a little down, New Hampshire Law School was receiving somewhere between 5 and 6 million each year. And it shows. It shows in how hard it has been for us to keep great professors, how hard it has been to keep the programs going, and what our students get when they get here. It is, it's not good. So we need to do a whole lot to restore the foundation of the law school. And with just a little bit of extra money, this law school, it's a gem. It's already providing enormous value. It could provide so much more. We're trying to establish a business innovators clinic. We're actually looking at the potential for a turnaround clinic because we think coming out of the pandemic, there will be a number of businesses that are right on the edge that need help with refinancing or reorganizing. We are looking at housing clinics. There are so many things the law school could do to help. One of the really exciting programs that I'm hoping we're going to be able to launch, which will tell us what Maine law will look like 10 years from now. We're working on the potential for a clinic branch in Aroostook County. And those kinds of things, which a year ago people thought would never be possible, have become possible, partly because everyone is getting much more creative and innovative, partly because technology allows us to talk to each other, even though we're all scattered throughout the state, and partly because the university and the world are changing fast. So let me just add one more thing about the university system. Some people have asked me whether the law school would be better off to go it alone. And the answer is a stark and absolute no. The university system is actually a wonderful institution. It has, in fact, stepped up when it had to. It has so much talent, and the new, the Graduate and Professional Center, unified accreditation, which the chancellor has brought into the state of Maine. We're going to be the first state to make this work. The new Alphon grant, all of these things come together to allow us within this university and with the university's support to provide cross-disciplinary education for our law students. They'll have an opportunity to go to some of the bioethics classes. They will have an opportunity to have a JD MBA if they choose, or a JD MPH. And I have to tell you that had the law school been on its own in the middle of the pandemic, it could not have survived. The university's system of standing up all of the testing, the organization, and the protection for students all came from the system level. And without that, we could not have kept our students safe. We could not have marshaled the resources, the technological resources necessary to continue high flex classes. So I'm very grateful to the university system for everything that they've done to help us, and they are working to move us forward. And it's 3 o'clock. So I will stop talking. I'm happy to answer questions, give you more information, just chat.
Thank you very much. I'm just going to look to committee members. We did start a little bit late, and so we have a couple of minutes if anyone has questions. Representative Harnett.
Thank you, Madam Chair. Thank you, Dean. Might not be too important, but I'm curious, did the students who did so well on the moot court get to go to Helsinki? And if not, will they get to go there in the future?
Well, you know, I'm glad you asked that question, because the answer is they did not get to go to Helsinki, and the students who are in the Arctic program have not been able to go to Norway or into the Arctic this year. But the budget restrictions have prevented our students from doing a lot of that travel in the past. So this has been terrible, I hate to say it this way, but there's been some blessing with the new technology. These students were able to show off their skills, and had this happened a year ago, I'm not sure we would have been able to afford to send them to Helsinki. It's a great question.
Thank you. Other questions from members of the committee? Senator Sanborn.
Thank you. And it's gonna be very difficult for me to call you Lee, but I could call you Dean. So in any case, it might be helpful. I served on that committee on the future of the law school, as well as the hiring committee for the dean search that brought you here. But it might be helpful for you to just speak briefly about why we can't just raise tuition in order to close the budget gap, in order to make this all work.
Thank you. That is a great question. And in fact, what has happened, so this gets back a little bit to how the law school got into this financial situation. In 2008, until 2008, law schools were actually a net revenue for the universities they sat in. For years, law schools brought money in. And in 2008, the economy crashed. People stopped going to law school. There were some serious issues with the budgets of law schools. And over time, the way the law schools responded across the country was to lure students back by discounting tuition, which was simple for Harvard and Yale and Cornell to reach into their enormous endowments and say to students, if you come here, we'll give you full boat. You don't have to pay any tuition. All of the rest of the smaller law schools in the country began struggling with that and started discounting tuition. UMaine was very slow to do so, and it took a while before we were able to have enough funding to discount tuition sufficient to make sure we're getting good, solid students And that's another long conversation. People came to law school who really weren't prepared. The bar exam numbers began to falter. People spent 3 years and a lot of money on an education that will not result for them in a license to practice law. That was not good. If we said we're just going to raise tuition, we would not attract students to this incredible institution. There is just far too much competition in the small, large, private, public law schools. We could not attract students into the law school if we raised tuition. You could raise it, you could double the tuition and then triple the discounting. But in the end, it's all the same. You simply cannot raise tuition right now. There's a question about whether the economics of law schools in the future will change some of that. And I think that has yet to be seen.
Thank you very much. And I too am having a hard time calling you Lee, but I'll say thank you very much, Lee, for joining us. We really appreciate you taking the time this afternoon and hope to see you again.
Thank you so much. Everybody stay healthy. Great to see you.
And now we have Attorney David Backer, who is going to speak with us about the Probate and Trust Law Advisory Commission, which is a mouthful. Go ahead, David.
Thank you, Senator Carney and Representative Harnett. So if the reception from me is incredibly clear and bright, it's because I am broadcasting live from Senator Carney's home district. So here I am, all dressed up with nowhere to go. I have to say that this feels a little strange to be sitting in my home in a coat and tie, but it's the appropriate attire, and it's good to see you all. And thank you all for your great service with our legislature. So I will be brief. It's not going to take me the full amount of time that you've allotted by any stretch. So the Probate and Trust Law Advisory Commission, known as PATLAC, has been in business for a little over 11 years now. Compared with our sister commissions, CLAC and FLAC, we are the new kid on the block. Our statutory charge is generally to review Titles 18B, the Trust Code, and 18C, the Probate Code, and recommend any changes that the Commission considers advisable. Our authority includes examining any other aspects of the state's probate and trust laws, including the substantive, procedural, and administrative matters that we, the Commission, deems relevant. The broad practice of trust and estate planning and administration takes many forms. It generally includes preparing wills, different types of trusts, financial powers of attorney, and advance health directives. The planning often includes components, some fairly simple, some not so simple, intended to minimize estate and income taxes. In almost all cases, the planning includes facets that have nothing to do with tax planning and that are equally important and often more so to the client than minimizing taxes. Planning to provide for underage children, planning to fund a college or graduate education for adult children, to protect adult children from their own improvidence or inexperience in handling money, to protect a surviving spouse, domestic partner, or children from creditors or predators, to provide financial support for a second spouse or domestic partner, and ensure that the assets ultimately will be distributed to children from a prior marriage or relationship, to provide for a beneficiary who has a drug, alcohol, or gambling addiction or dependency, or to protect a disabled beneficiary's entitlement to public assistance benefits. In other words, the goals of estate planning run far and wide. And although many of the planning techniques that lawyers use every day are essentially unchanged from a generation ago, new techniques are regularly added, and there's a constant evolution of the laws, both state and federal, that impact the world of trust and estate planning. And until the creation of PATLAC, we had no way to ensure that Maine's laws kept pace with the changes in the many federal laws that affect the broad field of trust and estate planning and administration, or ensure that our laws keep pace with the new planning techniques being created as a matter of statutory law in other states. PATLAC's role is to fill that void and serve as an effective clearinghouse for new ideas as Maine lawyers and judges encounter them in their daily work. We've set ourselves up procedurally to be as open and inclusive as possible. We work regularly with and receive input from many different individuals and stakeholder groups that have an interest in our projects. Groups with obvious interest in our work that we deal with fairly regularly include the Maine Probate Judges Association, the Probate Registers, the Maine State Bar Association's Trust and Estates section, an elder law section, the Maine Community Bankers Association, and lots of others. And we've worked closely with FLAC on issues of overlap in our respective commissions. In addition to originating proposed legislation, we frequently respond to the Judiciary Committee's invitation to weigh in with our comments on legislation that originates elsewhere and falls within the domain of Titles 18B or C. And we're happy to continue in that role, and certainly don't be shy about asking us to weigh in anytime our input may be helpful to you. We stand ready to be of assistance in any way that you all find most efficient to enable you to fulfill your obligations as members of the committee. And we look forward to working with you. And that's really the full overview of sort of what we do and how you will see us from time to time over the course of the legislative session.
Thank you very much, David. Does any member of the committee have questions? I'll give people a moment to think, because I have a question. How has the coronavirus pandemic affected the work that probate attorneys do? I would imagine that at least in advanced health directives, there may have been some changes. And then has that impact caused you to think about policy changes going forward?
Well, work certainly hasn't slowed down in the world that I live in. This last year was as busy as any I have ever had in my career. I think there have been a number of cases where clients have been sort of prompted to call to update their planning just in light of the recognized risks of living through a pandemic. But I think for the most part, life has continued unchanged in the world of trust and estate planning. The hardest part has been how to sign documents. And for a couple of months, our office was shut down without the ability for clients to come in at all. The governor's office did issue an executive order early on in the pandemic addressing ways to sign, witness, and notarize documents remotely. The protocol under that executive order was fairly cumbersome. I don't know how many lawyers actually took advantage of it. After the first couple months of being shut down, when we reopened, clients do come into the office to sign documents. So we do that regularly now. It's done with appropriate social distancing and masking, and they come in, they sign, and they get out. It's not an opportunity to sit down and review the documents. That's all done either by Zoom or phone before they come in.
Thank you. Other members of the committee have questions? Representative Babbage?
Thank you, Madam Chair. Hello, Mr. Backer. I was just thinking about one of the things that has always concerned me a little bit in state government. We have a lot of commissions, a lot of people volunteering their time or nearly volunteering their time. But sometimes we form these oversight or groups with people who have expertise, but are also stakeholders with interests in the outcome potentially. I mean, the conflict of interest issues in state government are amazing once you get into the voluntary area. But I was wondering, you mentioned PACLAC and who you take information from, and I just wanted to give you the opportunity. You know, other than institutional consultations, what about the little guy? So you mentioned the judges, you mentioned the banks. Who does PACLAC generally take input from in order to push ahead? Thank you.
That's a fair question. And when we revamped the probate code, and you know it recently moved from Title 18A to Title 18C with a complete rewrite. It was a several-year project, and we received input from dozens of individuals and groups that had a stake in the provisions of the new probate code, particularly in the areas of guardianship and conservatorship and the new concept known as supported decision-making. And those comments came from lots of different sources, from individuals and families with minor and adult children who had different disabilities, from different advocacy groups on behalf of families and children. So, I mean, that's one example where the input was really tremendously helpful, not only for the members of the Judiciary Committee, but for PACLAC as well, in framing and revising as necessary some of the proposed language of the new Title 18C.
Thank you very much. Do members of the committee have any additional questions? And we are, I think, right on time, more or less. Thank you very much, David, for being with us this afternoon.
My pleasure. Thank you for having me.
And now we move on to our next group of presenters. This is the Governor's Judicial Selection Committee. And we have John Hobson, Jerry Reed, and Tim Feely, and I know that they're all here with us. And so I will turn the floor, as it were, over to the three of you and just ask that if you let us know right now, I guess, if you would like to take questions as you're presenting or whether you would prefer to wait to the end for some questions.
Thank you very much, Senator Carney. My name is John Hobson. I am chair of Governor Mills' Judicial Selection Committee, and I do not mind being interrupted with questions. I guess I've, over the lifetime of litigation, gotten used to the judges questioning me right in the middle of a sentence. So I'm very happy to take questions at any time, and certainly after or before. What I thought I'd do is give a brief overview of what the Judicial Selection Committee does and our function, and then leave time for questions after that, because at least I was told by the person, I think it was the person who set this up, that I should allow plenty of time for questions. So I will do that. The Judicial Selection Committee is a creature of executive order. It's a committee that's actually existed by executive order since the mid-1990s. It, in fact, has existed prior to that time, although I don't know of any executive orders that, because I've actually spoken to the chair back when I was chair of Governor Baldacci's Judicial Selection Committee, Chuck Harvey, when he was on the committee, and got input from him in terms of his thoughts on the process and some other things. So it's been a fairly long-standing tradition. And the committee exists, I guess I would kind of describe it as the wide end of the funnel in terms of the judicial selection process for those individuals who are members of the bar who want to become judges in the state. It also has a function that I'll talk about in the renomination of judges. But for individuals who want to become a judge, the way the process works is that there's an online application. And here I have to actually give a tip of the hat to Derek Langhauser, Governor's Counsel before Mr. Reed, who revamped in a very positive way the application process. He put it online, he made it much more user-friendly, and I think really improved the experience both for those who are applying and for the committee members. And so if someone is interested in becoming a judge, they go through the online application process. The governor's office through chief legal counsel basically collects all those applications, and then the committee working with the governor's counsel now, working with Jerry Reed, the current governor's counsel, who's been a big help, goes through those and makes a decision of which of the applicants should be given an interview. The committee consists of 9 members throughout the state. Most have had trial practice, either currently or most currently have trial practice or certainly have extensive trial experience. So they're familiar with the courtroom, familiar with judges, familiar with what judges do. Then after going through the process of reviewing the applications, the committee comes up with an agreed upon list of people who will be interviewed. And in the old days, we would set up a list of interviewees who would then come up to the Capitol building in the governor's office. And we had the interviews in the cabinet room for the positions. That's changed a bit. Just as we are meeting today via Zoom, we've come up with a somewhat of a hybrid system of interviewing where there are a few people up in the cabinet room with the interviewee, a very few, and then the rest of the committee will participate by Zoom. The reason for that is a judge is an incredibly important position with an incredible amount of power over individuals in the state. And the committee felt that it was important, even in this time of social distancing, to be able to have some sense of interaction as part of the interview process. And so we've tried to maintain that in the COVID-19 world. And it hasn't been without its glitches, but I think overall it's been successful. We do look eagerly, as does everyone, to the time when COVID-19 restrictions aren't in place, but for the foreseeable future, they probably will be. So that is the process for getting the interview. After the interview, the committee kind of gives its thoughts to the governor generally through governor's counsel, sometimes directly to the governor. And then the governor makes her decision, because at the end, the Judicial Selection Committee is an advisory committee. The Maine Constitution provides, as it should, that the governor makes the selection. So the committee is only advising the governor on basically the attributes of the individuals who have applied. And then based upon the input from the committee and obviously the governor's own sense of the person and the position, a selection is made and then posted, and the nomination process goes from there. So that's how the Judicial Selection Committee process works. Then there's another component to it, which is the renomination process for judges. When there's an opening, there's an expiration of a term, because the judges will sit for 7-year terms, and one of the terms expires. The committee will basically review the performance of an individual judge and make a recommendation. And the review is in depth. We generally have a subcommittee appointed who will go out and talk extensively with practitioners before that particular judge and get input from all areas of the bar, all practice areas. and get a determination of what the job performance has been. And then based upon that information, a decision will be made in terms of whether to recommend or not to recommend to the governor whether a particular judge should be reappointed. And so the Judicial Selection Committee has, as I say, has a role in both the new appointees and the renomination process. And I guess if there's one poll star for the committee, and it's been true since I've been on the committee, and I've been on the committee since 2003 when it was, and right through, I was on Governor LePage's committee when Josh Tardy did a very, very good job chairing the committee, and then continued on when Governor Mills gave me the honor of requesting I chair the current committee. And the one poll star I think that the committee has always tried to look at is, number one, does this person have the intelligence and the background to be able to perform the job as it should be performed for the people of the state of Maine? But number two, do they have the judicial temperament? Are they someone who is going to represent the state and candidly the governor, because they're a representative of the governor when the governor makes the choice in terms of the performance of that job? And that's a decision and a recommendation that every committee member takes very seriously. And there's a lot of thought and effort that goes into those recommendations. So with that, I'll conclude the remarks and ask if there are any questions.
Thank you very much. I see lots of hands up, so I'll start with Representative Reckitt.
Thank you. I think you probably know, John, that I've been interested in this arena for a long time and have done a fair amount of talking to the committee and talking to the governor and talking to the committee, the Judiciary Committee, about particular choices, particularly in the area of renomination. But what I mentioned this morning to this group, and which I'll now directly mention to you, is that it's extraordinarily frustrating to me as a member of this committee, which I've now been for, this is my 5th year, to get the information on a proposed candidate at the late date that we generally get them. And I would hope that we could try to get them 2 or 3 days early so that we might look at them more carefully and have a little chance to dig around ourselves should we choose to do that. So that's my request to you, which is sort of not a question, but my question is, can you do it? I don't know whether the process will meld itself to it, but it would be extraordinarily helpful, and I would really appreciate it.
I don't know the logistics, but we can certainly try and get you the information. It makes a lot of sense to me.
I mean, otherwise we don't, it turns into more of a rubber stamp, which I don't think any of us necessarily want to be, because if we're going to have this duty to put these people forward to the Senate, we really should have our heart in it. And I don't think we can do that if we don't have the information in sufficient time. So thank you.
Thank you, Representative Reckitt. And I would just underscore that request, because we're finding that we're all very busy and we want to bring really high quality work to our committee work. And if we have that information in advance of the hearings, it does elevate our ability to pay attention during the hearing to the nominee, and it allows us to be really well prepared and do our best for the state of Maine and for the nominees. So we appreciate any efforts you can make in that regard.
We will.
Thank you. I saw other hands up. Was it, can you re-raise your hands, please, members of the committee? Oh, Senator Keim?
My hand wasn't up before, so I was trying to wait to make sure I wasn't jumping in line ahead of someone, but it's difficult on a screen like this. So I would reiterate what Lois said about not wanting to be a rubber stamp, and specifically, I'm wondering a couple of things. We heard earlier from the Bar Association that they put out their own questionnaire around judges, but rather than share the actual information, they just sort of give a thumbs up or a thumbs down. And so I was wondering, so I have two questions, so I'll let you answer both. But one question is, has the Judicial Selection Committee questioned the Bar Association and asked for that in more detail to be more helpful in your considerations? Because I also learned today for the first time actually that they share that information with the judge themselves, of course, taking off the name of the lawyers who might be commenting. But I find it curious that they can share it with the judge, but not with the people who are tasked with whether or not to reappoint. And then the other question I have is, during the Baldacci administration, the committee, while we weren't given the more in-depth files of a judge, apparently the Judiciary Committee was allowed to view files on judges. And I'm wondering if we could be given the ability to view these files, maybe the files that the Selection Committee is using. But I find what we're given, it definitely is much less in depth than what I've heard other judiciary committees have had in the past. And I think, again, doesn't help us do our job, but kind of creates us as a rubber stamp, or that we have to go out and do a lot of research on our own, which we don't necessarily have the same ability to do. So I'd just like your comment on both of those things, if I could, please. Thank you.
If I could start with the Bar Association, that's somewhat of a topic that's near and dear to my heart, because I actually, when I met with the board of the Bar Association once, when I was in the Baldacci years, about this topic. The short answer, I'll give you the short answer and then the longer answer. The short answer is the Bar Association is not going to share that information other than the thumbs up or thumbs down. The longer answer is that the Bar Association, apparently, when they came up with this format of sending out questionnaires, I believe it's in the 3rd year and in the 6th year of judges, essentially, they wouldn't like me to characterize it this way, but I think this is accurate. They essentially struck a deal that the questionnaires would be confidential, a deal with the judges. The questionnaire would be confidential and would not be shared beyond the committee at the Bar Association that deals with the questionnaire. And I believe the board may also get that information, but that's subject to check. But the board, the committee that oversees the questionnaire gets the questionnaire, and I believe the board does, but I'm not 100% sure that. It is not shared beyond that, and it is jealously guarded. They believe firmly that there was a function of an agreement that was made with the judges at the time, and that agreement serves the bar and the judges well, and that in the end they are making a recommendation from the input that they think is fair, and they appropriately so perhaps say, you know, for other bodies such as the Judicial Selection Committee, you have your own resources, you have your own sources of information, you should tap those information. Ours is the information that we gather, and that is our information. And as I say, it was done in a context that there was an agreement that it would be kept confidential. So I am confident that those questionnaires and that information is not going to be shared with this Judicial Selection Committee, as it has not with prior Judicial Selection Committee, because I tried mightily to get some kind of an agreement, to get some kind of a greater sharing of information about that, and really did not get anywhere, although they were very, very polite and diplomatic about it. So that's the answer to that. And in terms of the file that the committee sees, I'll have to look into that. I didn't realize you were getting anything less than any other previous committee. And certainly, I'll take a look at that. I just don't know enough about that issue to make an intelligent comment about it. But I'm not aware that it's any different, but I'll certainly look at that.
Thank you. We've got a couple of more hands up. I saw Representative Babbage first, and then Representative Harnett next, and then others, please let me know.
Thank you very much, Madam Chair. And thank you, Mr. Hobson. Great to see you again. Lois brought the subject up. I think all of us that are veterans on this committee have felt, are we doing our due diligence? And honestly, if in fact we have a red flag, at least one that we personally feel is a red flag, to do so publicly, to bring that up publicly at a nomination hearing when family is gathered and the bar has made their recommendation, and you have made done a great deal of vetting and made your recommendation. I think it puts some pressure on the committee to be merely a facility to confirmation. And so my three concerns, I guess, one would be timing. And I don't know about 2 or 3 days, Lois. I would need more than that. But mine isn't really to dig around necessarily. Mine would be to contact the nominee, him or herself, in order to get a clarification on something. I realize these are personnel matters, and I honestly think that with the bar was testifying today or presenting today, it seems to me that in order to launch any kind of serious accusation could be done so at personal risk. The lawyer population in this state is not so great that things can be calculated to their root, in my opinion. But what I would ask you is do you think that there is that intimidation to be forthright in these surveys that are subscribed to? And then secondly, I would like to know the pressure on the vetting on your group as far as how strong is the applicant pool for these positions, especially in rural areas. So when somebody's up for renomination, and all of us are human beings with frailties, how do you decide what is a correctable tendency and what, if ever, and I don't think it's ever happened in my experience that that you would not make a renomination. But thank you for commenting on any of that.
Let me turn to the renomination process first. There is no pressure on the committee to make any particular determination in the renomination process. And it is the contacts and the feedback is given to us. So, and the person who is giving it understands it is being given us anonymously so that it can be done. We can get the unvarnished truth about the performance of a particular judge. And we make our decisions on that. So I think in terms of renominations, we take into account that the person has been had at least 7 years of public service that they fill the term. But there is scrutiny in the renomination process. And I'll say the mere fact that you haven't noticed that someone hasn't been renominated does not necessarily mean that there haven't been those who have not gone on to another 7 years. There's no reason to humiliate someone if they haven't. So this process is a process that is stringent. I mean, we're bearing in mind that the judge has public service in the past, and I believe it's effective. In terms of the input into if a particular candidate has a flaw and be able to air that in outside of public comment. Actually, during the Baldacci administration, when I was chair for a bit, I welcome and would again, if there's a particular pressing issue that a committee member believes needs to be addressed, and it is a sensitive one that in the public context is difficult to raise, that it can be done in a context prior to the hearing, at times if necessary with the nominee, or at least an explanation. I am always willing to meet with any particular committee member about any concern about any nominee at any time. Well, with some limits, but for the most part. And I guess these days it would be Zoom. I'm still getting used to, I'm kind of an in-person type of individual, and I'm still getting used to the video Zoom age, but it would probably be done by Zoom. But at the end of the day, if there are serious concerns with a particular candidate, we have in the past certainly tried to set up a mechanism where those concerns could be addressed outside of the public hearing process if they're sensitive, and therefore allow a full airing of what the concerns are and what needs to be addressed, those, so that the committee member can go into the public hearing believing they have the full information in which to make a decision on a particular nominee.
I just want to clarify that you've both touched on this a little bit, but that, you know, when we do a nomination hearing before our committee, we give notice and the public does have a right to participate. And so when we're talking to nominees, for example, on the subject matter of the nomination, that would be in the context of a committee hearing. And then I recognize Representative Harnett, and then I know that you, Representative Moriarty, also would like to speak. Go ahead, Representative Harnett. Representative Harnett, did you want to speak? I think you're muted. It looks like there might be an issue. Representative Moriarty, why don't you go ahead?
Okay, will do. Thank you, Madam Chair. John, apart from your committee and the main bar committee, who else weighs in on a renomination?
The Maine Trial Lawyers Association weighs in on renominations, and I don't, sometimes the local bar associations will weigh in if a judge sits in a particular area. Not always, depends on how active the bar association is.
Sure.
But that, in terms of organized groups, those are typically who weighs in on renominations. Again, I'm not sure how this is going to work in the Zoom age. There have been at times in the past members of the public who have a particular interest in a particular judge because of something that occurred, and they will also.
Well, quick follow-up then. Do you all attempt to achieve consensus, or do you report independently to the governor, irrespective of the other committee's conclusions and recommendations?
We're independent of those committees. I mean, they make their determinations upon the criteria that those organizations have. We make ours entirely independently, although the reality is that the base of the membership is the trial bar, and so many members will be members that we will seek input from. We'll also be giving input to those organizations.
Of course. Yep. Thank you.
Representative Harnett.
Hopefully this time it's going to work. Sorry about that. Something just took over the screen. I'm on a computer that's not mine. And thank you, Madam Chair, and thank you, John, for everything that you do. My question revolves around, what does the court look like? I think we can all agree that judges should reflect the population whose lives they control and the decisions that they make in terms of diversity of gender, race, ethnicity, etc. And I'm wondering what efforts the commission takes to make sure that they are reaching out to create a judiciary that looks like the population of Maine, particularly a population that is changing now in terms of new Mainers and more people of color and indigenous populations. So curious as to how you deal with that.
The way we've tried to deal with that is to put out the word, including not just members of our committee, but with people that they know, to try to encourage people with diverse backgrounds to apply to be a judge, and to try to grow the applicant pool. And we've made endeavors and outreaches to try to increase the applicant pool, increase the diversity of the applicant pool. And the pool ends up being what it is. There are a lot of reasons why people don't want to be judges, and it isn't the job for everyone. But the committee has made an effort and continues to make an effort. I've met with individuals who I thought would be a good applicant, but there are not always, the job doesn't have the allure to everyone. So the committee makes efforts, tries to get people to apply, to go through the process, because they'll go through the same process. Hopefully we will continue to do that, and hopefully we'll get first pool.
As a follow-up, does the advisory group contact other organizations that might have members that reflect the diversity of Maine? Actively seeking out organizations that might be able to provide you with suitable candidates?
We haven't really tried to go to organizations as such. I'm not sure exactly how the Judicial Selection Committee would do that. There are people who are our members who are members of organizations who have done it individually, but certainly not as a formal committee. And I'm not sure exactly how that would work in terms of the Judicial Selection Committee itself.
Thank you.
Thank you. I see that Representative Moriarty has another question, but we are 5 minutes over. Is it something that is a quick question?
It's very quick, actually.
Go ahead.
To follow up on Representative Harnett's questions, John, to put it bluntly, does your committee beat the bushes to come up with nominees and those who are willing to fill out the online application?
We certainly make an effort. I don't know whether first of all, we try to encourage people who we believe have the qualifications to become a judge, in terms of the professional qualifications. So right away, the pool of people that you're going to be approaching, it's an important job, as you know. And so you don't want to encourage people who do not initially have the qualifications to set them up for failure in the process. But I certainly believe that the committee itself has made efforts for outreach, and will continue to do so, and welcome suggestions about how we can do better. Absolutely, because we all benefit when we have a larger, more diverse applicant pool to choose from.
Thank you. Thank you.
Thank you very much to all of the members of the Governor's Judicial Selection Committee and the Governor's representatives. We appreciate you being here this afternoon, and thank you for your time. We are going to move on to our next set of presenters. This is the Permanent Commission on the Status of Racial, Indigenous, and Maine Tribal Populations. And I know that many of them have already joined us and heard a little bit of our discussion. And so I would welcome you to begin. Representative Talbot Ross, I would like to recognize you first and ask you to introduce yourself.
Well, thank you very much. My name is Rachel Talbot Ross. I represent House District 40, which is on the peninsula of Portland, and was a former member of the Judiciary Committee. So it's good to be back and see some of you. And Looking forward to our discussion this afternoon. I am joined by one of our commission members, Keith Bisson with Coastal Enterprise, and the two of us will deliver the presentation today. I'll ask Madam Chair, is it for Mr. Bisson to introduce himself as well?
Yes, that would be fine. And would you like the members of the committee to hold questions until the end or ask as we go through the presentation?
I think it's just as well to probably hold the questions to the end. That might work. We can just get through the presentation and then we can have a great discussion. Thanks for the question.
Go ahead.
Yeah. Thank you, Representative Talbot Ross and Madam Chair. I really appreciate the opportunity to talk with all of you today, along with Representative Talbot Ross. My name is Keith Bisson. I'm president of Coastal Enterprises Incorporated. We're a community development financial institution based in Brunswick. And I do have just a short slide deck that I'd like to share. I'll just go through it very quickly, and then we can get to questions, because I know Representative Talbot Ross and I definitely look forward to your questions and the discussion. And I want to acknowledge Cameron Brewer, who's on the call with us, who helped put this presentation together and who's working with us through the Volunteers of America. It's just started with us a couple of weeks ago, so just a tremendous resource to us and the state of Maine. So I'm going to try to share my screen here, if you bear with me for a moment. Can everyone see that?
Yes.
Okay, thank you. So I think you're probably all aware of the Permanent Commission on the Status of Racial, Indigenous, and Maine Tribal Populations. Just a little bit of background. It was created by the legislature in 2019. It's an independent entity, and it's actually now composed of 15 members from a diverse group of individuals that represent various components of Maine's racial, indigenous, and tribal populations, as well as a couple other seats, including, for example, the one that I fill as a community development financial institution, and one or two other more sort of topical things around policy. But we are, as on a statutory basis, empowered to advise all three branches of government, to submit legislation, and to engage in some level of fundraising to support the work that we're doing. We did engage in an effort this past summer that was pretty exciting, that involved 55 state legislators, and maybe including some of you to review something like 450 pieces of legislation that had remained open after the legislature closed at the onset of the pandemic. And that was a really great process, where we also developed a framework of how to assess legislation in terms of how it increases or decreases racial equity. If you think of our work in a few ways, I know you got the one pager that we sent, but we're focused on three pillars, if you will. One is to advise all three branches of the government, but other pieces are to further research, data collection, and analysis that are relevant to the statutory purposes of the commission, and then a third area of public education and engagement, and all with the goal of confronting structural racism in Maine. And I don't think we have time to this bill here, but nonetheless, that is one of our guiding stars in our work. And you're probably all familiar with much of this research. It was just addressed a little bit in terms of how the important role of judges and representing the people of the state of Maine as well. I just maybe the clearest example of most recent note is really the impact of COVID, particularly on Black Mainers, who are much more likely to experience COVID than their white counterparts. I've talked a little bit about the role of the Permanent Commission in terms of advising the different branches of government, and with the help of people like Cameron, we're really going to be looking more at researching and analyzing data on ongoing issues in the state of Maine. and ideally engaging the public, because that is another core part of our work. Some of the areas of policy that we're, very focused on are I won't go through this entire list, but obviously we're here to talk to you who are working in the judicial system, and so that's a core part of what we're looking at. Some of the guiding principles, I think that we are probably worth discussing more, but something that we've been looking at as a commission is this list of bullets here. One is acknowledging that structural racism is real and has real world consequences for all the people of Maine, of all, no matter their race or tribal background. It affects all of us. We're really focusing on investing resources into research data collection and policy advisement, ending race-neutral attempts at addressing structural racism, developing policy solutions led and informed by impacted communities. And I think this is, again, this addresses one of the representative comments about recruiting to the judicial system. And that's been, I would say, really an eye-opening experience for me since the commission really launched its work formally in March, to have that different perspective on the commission from people with lived experiences for all of the issues that we're looking at. I think the tribal component is very important in terms of government to government joint decision making on policies that impact tribal nations, and institutionalizing racial impact reviews for all legislation. And I think you all received the report that we produced that was released earlier this fall, that where we identified a set of priority bills out of those 450 pieces of legislation that the commission looked at over the summer, using a framework that looks at how that legislation either increases or decreases racial equity. I think some of the things that we wanted to talk to you about in terms of what you can do now in your work. One is to advocate for the collection of data. We do, being a data-driven commission is really important in informing our work, and that was a key part of the framework that we developed over the summer under the leadership of Representative Talbot Ross, who's chair of the commission. So I think focusing on that data and making it accessible is really important. Secondly, is actively seeking the Permanent Commission's recommendations in crafting and passing legislation, particularly, again, seeking input from people with lived experience. Excuse me, sorry. We do have a bill, or there is a bill pending, LR 4036, an act regarding the Permanent Commission, which would allocate funding for the commission in the state budget, including funding for staffing, which we do believe is a really important piece of the work to further institutionalize this work and create the resources necessary to do the work. What our purposes as laid out in the statute are quite ambitious, and between the three pillars that I described to you of advising, researching and doing an analysis, and public education is a fair bit of work, and we are currently a 15-member volunteer commission. The other bill is LD2, an act to require the inclusion of racial impact statements in the legislative process. So I'll stop there. I know I've gone on a little longer than I intended, and we would love to hear your questions and discussion.
Thank you very much, Mr. Bisson. Just a general question. I don't know if you've provided this set of slides to our committee clerk, but if you haven't, could you please email it to the clerk? I think it would be helpful.
Absolutely.
Thank you. All right, let's see now. Okay, now back, I can see everybody. Representative Talbot Ross, did you have anything you wanted to add before I open up to questions?
Well, thank you, Madam Chair. The one thing I would add, because of the jurisdiction of this particular committee, is the permanent commission is really supposed to work hand in hand with the Maine Human Rights Commission. The Maine Human Rights Commission, if you think about it, the Maine Human Rights Commission is an area for redress, right? What the permanent commission does is we're hoping that the data-driven process that we undertake in looking at racial disparities, along with public education and public engagement, that will actually start to lessen the burden of the Maine Human Rights Commission. So if you think about these two things working hand in hand, we would be the preventative piece, and then you have the Maine Human Rights Commission as the area for redress. The Maine Human Rights Commission, as you all know, has a budget of $1.5 million a year and has 13 staff members. So we are in the process of trying to build up the permanent commission so that we can have an impact on the ways in which we decrease racial disparities and we address systemic racism, but all in all, to benefit the people of Maine so that we don't get one way of looking at systemic racism, which is only through the lens of redress. So I would just add that given your jurisdictional, areas.
Thank you very much. I see some hands up from members of the committee. Representative Evangelos, I saw your hand first, so would you like to go ahead with a question? Oh, you're muted.
Thank you, Madam Chair. And hello, Representative Rachel Talbot Ross. I just want you to know how much we're going to miss you on the Judiciary Committee. But our introductory segments that we've been experiencing the last couple of days, there were several guests, including you, that I'm going to be asking the chairs to invite back so we can have an in-depth discussion, and especially in the areas of racial inequity and the treatment of our tribes. I'd like the committee to spend several hours with you so we can really delve into the serious questions and the information that you can bring to the committee that will help us form our policy and deliberate on our bills. So you'd be willing to appear, wouldn't you?
Absolutely. Thank you for the question, Representative. At any time, I often say that during the last 4 years that I've served in the legislature, my favorite time was always spent in Judiciary Committee because of my colleagues that I served with in the past. But this is a great committee, and I would do whatever is necessary to lend some resources and some help at any time, Representative. Thank you.
Thank you. That's all I had, Madam Chair.
Thank you very much. And thank you for your kind offer to come back and meet with us, Representative Talbot Ross. Other committee members have questions? I'm just taking a scan. I'm not seeing any hands. Perhaps we'll save those up for when we next meet. And thank you very much to you and Mr. Brewer. And I'm losing the other face on the screen, but thank you very much for joining us this afternoon. And that takes us to the very last presenter for today.
Thank you very much.
Mr. Bisson, sorry, I neglected to remember your name.
That's okay.
And then our final presentation is the Family Law Advisory Commission. And this is Judge Mary Kelly who has joined us. And Judge Kelly, welcome to the Judiciary Committee. I will just let you introduce yourself. And do you prefer to have questions during your presentation or at the end? Thank you.
All right, so you asked whether I prefer questions at the end or during my presentation, and I responded that whatever works for you is fine with me. Thank you.
Okay, we'll play it by ear then. Why don't you go ahead? Thanks.
Thank you. So Senator Carney and Representative Harnett and all the members of the Joint Standing Committee on Judiciary, some of whom I've met before. Hi. My name is Mary Kelly, and I'm a district court judge, and I sit in Portland. And I'm also the chair of the Family Law Advisory Commission, also known as FLAC. And FLAC thanks you so much for inviting us to appear before you today and to give you some sense of what we do. And I know you've had a long day. I think the primary message I want to deliver, and then I'll talk a little bit more about how we're formed and so on, but we see our role primarily is to assist you. So when there are family law bills that you're considering, or if there's an issue that hasn't been addressed in a bill and you would like us to look at it, we would be delighted to help you. So if you take nothing else from what I say, that's our message, that we're here to help with family law. And indeed, that's what we're created by statute to do. So FLAC was established about 23 years ago, and it was established for the purpose of conducting a continuing study of the family laws of Maine. And our enabling statute is set forth in Title 19A. And that statute directs FLAC to examine and evaluate Maine's family law statutes and to propose amendments to those provisions as the Commission deems advisable. There are 11 members on FLAC who are appointed by the Chief Judge of the Maine Supreme Court. And by statute, all members must have experience in practicing family law or be knowledgeable about family law. The statute allocates certain aspects of family law that need to be represented on the Family Law Advisory Commission. There's a Superior Court Justice, there's a District Court Judge, there's a Family Law Magistrate, and there's a Probate Judge, who's one of your own, Judge Libby Mitchell. And then there have to be 2 members pursuant to the statute from the Family Law section of the Maine Bar Association, a representative of Legal Services Organization, and that role is served by Melissa Martin from Pine Tree Legal. We have a representative from the mediation, the dispute resolution services of the court, which is CODRES. We have a representative from DHS, and we have 2 members of the public. And right now, that's those public members. One is Dr. Franklin Brooks, who's a professor at the University of New England and also a licensed social worker. And the other is Tim Robbins, who's the director of the Kids First organization. So these are a lot of voices from a lot of different parts of family law. We meet once a month ordinarily. This summer, we were quite indulgent and took some time off over the summer. Prior to COVID, we would meet in Augusta once a month and work together there. We've obviously, since COVID, had to change that practice, and now we meet by Zoom. It's a total volunteer organization. We don't have any budget, but what we do have is really 11 remarkable people, I think, who are really committed to the work of the Family Law Advisory Commission and willing to donate their time and expertise. We also have people from outside who aren't formally members of FLAC, but who come to us on a regular basis. Debbie Willis from the Attorney General's office, who's an expert on child support and the head of their child support division. And then from the law school, Professor Deirdre Smith, who's been a really invaluable resource to us and does enormous work and helps us with research and with formulating legislation. As I said at the outset, ordinarily during this session, we're responding to bills that other people are preparing. We get them, we look at them. If we think we should comment on them, we do. We provide you a short report, giving our thoughts. It's good, here's how it could be improved. And then over the years, the Judiciary Committee, have often asked FLAC to work on particular issues. And of course, as I said, we're really happy to do that and have done that on various issues, including most recently on the probate code, the provisions dealing with adoption and guardianship. We also ourselves come up with ideas, especially out of a session, and sometimes we struggle coming to consensus on those. Most recently, and we're still doing some work on this, we worked on the issue of when parents' rights are terminated, to what extent, if at all, should the rights of the original parents, should they be preserved in any way? Should there be open adoption, for example, in Maine? We've worked on and submitted legislation on name change provisions. And now we're working, and it's, I think, going to be a long process, but we're plan to work hard on the issue of spousal support, on which there's been a lot of minor legislative changes, but we're looking at a more profound issue, which is, should there be a system such as there is for child support, which easily calculates what spousal support should be? And that has given rise to questions, well, do we need spousal support at all? And what does it serve? What is its purpose? And so we have interesting philosophical discussions. And then my job is to push the group to eventually get some consensus, because we can't be endlessly philosophizing. We need to come to a resolution. And so that's what we try to do. And we work very much by consensus. Occasionally we'll have to file a report and say there are some dissenting views, but that's very unusual. So it's a great group of volunteers who do a lot of good work and who are very eager to help you. And that is my presentation. And now I'm happy to take your questions.
Thank you very much. And I just want to offer a big apology to Tim Robbins. I saw that somebody whose identity I couldn't figure out was in the waiting room, and I was unsure whether it was appropriate to admit you, but welcome very much to our meeting. I'll give you a moment to introduce yourself and address the committee as well.
Well, thank you. Again, I'm Timothy Robbins. I'm the public members of FLAC. Really here today to support Judge Kelly, and she does a fabulous job leading us, and everything she said is absolutely accurate. We spent many hours talking about various aspects of family law that really gets down into the weeds. It's been a pleasure of mine. I'm a relatively new member of FLAC. Been a pleasure to be working with this group, and very much we tackle a lot of issues, and sometimes it is hard to focus, and Judge Kelly does a fabulous job reining in the cats. So I'm really here today to support Judge Kelly and the FLAC Family Law Advisory Commission, and it's been a privilege to serve, and I'm happy to answer any questions. Also, if you have any of the public member. Thank you.
Thank you. That's very nice, Attorney Robbins. I appreciate your support.
So I'll turn to members of the committee and ask if there are any committee members who have questions for Judge Kelly or Mr. Robbins. I am not seeing any hands. I just toss out a question. Is there legislation that FLAC is putting forward that will see this session in judiciary?
I think there were some bills that we proposed last year, including the name change bill, that you'll see again. And we also worked on it's a uniform law dealing with acknowledgements of parentage, and I think that's already in front of you. So those are carryovers. I suspect because of the really intensity of the work involved, the spousal support statute may not come until next session. So I think for now that's all. I think we don't have anything else before you. The name change, the acknowledgements of parentage, and in our meeting last month, it was clear that there are a lot of bills that you have before you coming from other places, which clearly touch on family law, and which we'd be happy to weigh in on.
Thank you. We really look forward to hearing from you during the upcoming session. And I'll just ask one more time if there are committee members who have any questions. All right, I am not seeing any hands. Thank you both very much for spending time with our committee this afternoon.
Thank you for having us, and I'm sure you've had a long, exhausting day, so thank you. We appreciate that you were still willing to hear us out. So have a good session and let us know if we can help. Take care.
Thank you.
Committee members, before we adjourn, we've had a full day of work, but before we adjourn, are there any topics that committee members would like to discuss? Representative Evangelos?
Thank you, Madam Chair. I noticed that an item was added to the agenda that we could have a short discussion or make some comments. So I have three specific comments I wanted to make today. I know this is going to be a long road in front of us, but given some of the things that happened on the Zoom call today, I'm not convinced that once we get to the public hearing stage on controversial bills, when we're hearing up to 40 or 50 witnesses, when our own House chair couldn't even get on the Zoom call, I'm not sure this is going to work. So I hope, I know there's discussions underway, but I've never felt less prepared. I need my paper files in front of me to take notes. And I wrote both of our chairs this morning and I expressed those concerns. I know you're aware of it. I'm not going to elaborate on it. The second thing, I was concerned in the discussion with the main bar today when Senator Keim raised a question, because it appeared the answer was that the attorneys were afraid that if their names were revealed that they would suffer retribution. So if that's the case, we got bigger problems than we even know about. So I'll just leave that one at that. Lastly, I do have a report here from the Prison Policy Initiative. It's a nonprofit organization around the United States that studies conditions in our prisons and specifically around our release system. And it grades the release systems of all 50 states on the basis of how we're allowing our rehabilitated prisoners out of prison. And, I got the feeling from last week's hearing that we didn't want to get into difficult questions with our guests today, so I held off. But Maine received an F- from this organization. We abolished parole. And since we've abolished parole in the 1970s, Maine has never allowed one prisoner out on executive clemency. And we're talking about prisoners who have been model prisoners, have never gotten in trouble in prison, that have learned bachelor's degrees and master's degrees. And there is no pathway for them. They never, ever get out even one day early. And one reason why I filed the parole bill. I mean, pardoning a dead guy 5 years after he died, Don Gellers, isn't exactly a sign of progress. I'm very, very concerned about this. And I'm hearing from prisoners, and I'm serious about this. I'm hearing from prisoners almost every single day. They call my house and they write me letters. I got a stack of letters. And the biggest problem revolves around people that were 18 or 20 years old when they committed, still with a teenage mind, they committed their act of violence. And they went on to become model citizens for 20 or 30 years. The release plan we have, the structured release, disqualifies them immediately because of community sentiment and other things of that nature. So we have some unbelievable work being done inside the Maine State Prison, but it never results in a reward or a second chance. I believe in second chances, but the Maine State Prison system is not operating under that understanding. We're just not letting, and we can elaborate on this discussion later. And lastly, and I would encourage our committee members to do so, but we've been welcome to submit suggestions to our chairs as to the guests we want to come back so we can have real discussions and questions and answers. And I plan on doing that. And I would encourage my fellow senators and representatives, whoever you want to hear from more in depth. Representative Harnett told me that it would happen. So that's all I have to say. But if anybody wants me to share the Prison Policy Initiative studies, it's disturbing to read it. And I'd be happy to share it with you. Thank you, Madam Chair.
Thank you. Yeah, I would like you to email me a copy of the report, and I appreciate you bringing it up. Thank you. Representative Moriarty, you had your hand raised.
Sorry. I wanted to follow up with Jeff's comment regarding young adult convictions, specifically the age bracket from 18 to 20. I've been contacted by a constituent about whether these convictions can be expunged. It appears that they can't because only the governor has the power to pardon. But then there's the matter of sealing the records of those convictions. And in the 129th, there was a bill pending. I have it as LD 776. Which wasn't reached with the early adjournment, but which would have provided a sealing mechanism for the records of young adult convictions. I've been unsuccessful in finding out whether the sponsor of that bill last legislature has either reoffered it or knows of someone who has. And Jeff, I don't know if you know the answer to that question, but I'm trying to find it out because my constituent wants me to introduce something like it now. And I don't know that that's going to be possible, but in any event, it's a valid point.
Stephen, I'm sorry, I don't know the answer to that, but we do need to do something. Thank you.
Yeah, let's take a look at that. And our analyst, Peggy, is waving her hand, and I think she might have an answer to that.
That would be great.
And I would just
there is a bill that has that same title. An act regarding a post-judgment motion by a person seeking to satisfy the prerequisites for obtaining special restrictions on, anyway, that title, it's LR 1340. It has not been printed yet. The sponsor is Representative Talbot Ross.
In fact, she was the sponsor of LD 776 last session, and I've emailed her twice and haven't had an answer. So I'm glad that you knew that, Peggy.
All right. Any other committee business that we'd like to address this afternoon, Senator Keim?
Thank you, Madam Chair. Yes, I actually want to piggyback on what Jeff said, and it might be different a little bit for all of us in how we're accustomed to doing committee work, but I find it incredibly difficult, the thought of moving forward without having printed bills and papers to work with. And I think that we should more highly value the work that we do, because every single person in the legislative branch of government is there to make sure that the voice of the people is heard and that we do our work really well. And every system that we can put in place to make sure that happens is appropriate and good. And I recognize that we have need to have safety precautions, but I think they still need to fall secondary to the work of the people being done, right? We can do both, but the main purpose is to make sure that the work of the people is done well. And every one of us is probably a little bit different in how we like to work and our adaptability with technology, but the amazing amount of information that's now coming through on my email that generally I am sitting in front of me and able to just take one paper, sometimes cross-reference things, writing things down. I mean, that's the way I work. That's the way I do good work. And follow through on all of the different details that kind of get thrown in front of us in a day. And I also serve on GOC. We're getting all of our information printed and given to us on that committee. So I understand, the clerks have, new issues. That was one of the things that was brought up. They had, have new responsibilities, but they also have less responsibilities in some ways as well, because there aren't people at the State House. And, not everyone may want printed material. Maybe they're fine without it. But I think for those of us that do, it's pretty critical that our voices are heard and that changes are made to allow us to do good work. So I think, I'm going to reach out to the Senate leadership and tell them that I would encourage anyone that also feels that they're limited with this new policy, that they reach out to leadership, and that we keep on until we get some changes and some adaptation in the policy that works for us.
Yeah, thank you for all of your comments. Representative Harnett is next.
Thank you, Madam Chair. And, I hear those concerns loudly and clearly, and I assured Representative Evangelos today that he's not the only person I've heard this from, Senator Keim as well, that this issue will be raised at the chair's meeting tomorrow morning, because I am hearing it from lots of folks. And we do have different work styles. We also have different technological skills. But with that, my problem today about getting onto the meeting was just a fluke that happened with being booted off the meeting. We are going to have some struggles moving forward, and I just want to thank everybody. I know it can be frustrating, but I do want to thank everybody for their patience as we work through this. We'll get better. It's not going to look like it looked before, but I think by working together and being patient, we can still do very good work. But there are issues that need to be addressed, and I will raise them. Thank you, Madam Chair.
Representative Babbage.
Thank you, Madam Chair. You can hear me, right?
Yeah.
Yeah, I appreciate, I guess, the discussion. I just wanted to express my point of view to the chairs and to the committee that, I'm 71 years old. I just read that I'm 10 times more likely to be infected by COVID than somebody 10 years younger than I am. I do not want to expose certain people in my family. I'm not anxious to get back to Augusta at all until I'm vaccinated, at least. And so I don't intend to go back. Now, saying that, I depend very much on the organization and paper that comes from the State House. So I'm frustrated that I've gone through 2 cartridges of toner in about 4 days. But the fact of the matter is, yeah, maybe there should be an appropriation for us regarding what we have to do at home here. But I want to just share that I feel the frustration, but that I also understand the need and am willing to make the sacrifices necessary, do as best I can. But I do say there is a paper and toner shortage at my house right now.
I'm going to call on Representative Moriarty first because he hasn't had a chance to weigh in, but we will get to you. Don't worry. Representative Moriarty?
Just very quickly, I want to echo everything that Chris just said. I depend upon paper as well, and I've gone through reams and reams to date. I do think at a bare minimum, when we are expected to review significant reports, whether interim or final, from various committees, that the state has an obligation to provide us with printed copies. I don't think we should be required to print off our own. We can't bind them as well, and it's just more than should be expected of us. And I don't think, I realized a year ago when COVID broke out that there was concern about the transmission of the virus from surfaces. I think that's been dispelled to a large extent. So I don't think that paper is considered to be a means of transmission medically these days. And then finally, with regard to the cost issue, it seems to me the state is saving so much in mileage and per diems that it ought to be able to afford the cost of paper and postage.
Let's see, Representative Evangelos, and then Libby and Sanborn.
Thank you, Madam Chair. Am I muted or no? I'm good. Very briefly, I ran the numbers, approximate numbers on what the legislature is saving a day by working remotely. It's over $30,000 a day. So if people like Soupy need a hand, they've got the money. And so I want Representative Harnett and Chair Carney to make that point that this isn't an additional cost. They're saving approximately $38,000 a day by keeping us at home. And they can apply some of that money to get the clerks the help they need, because I know Soupy's time is now more tied up with technology, and So I just want to implore you that to make that point that this isn't even a financial issue, as Representative Moriarty just pointed out. And thank you for that. That's it.
You're welcome, Representative Libby.
Thank you, Madam Chair. I think that Senator Kaim and Representative Evangelos have expressed most of my feelings on the need for printed copy, but I'd just like to put that out there as a first-time legislator, that sometimes it's hard to even know what to print, and I think it would be incredibly helpful to have the printed copy, to have that organization that I have not had before to see what we do need, and again to be able to reference back and forth to other documents. I want to do a good job for Maine people, and I feel like the lack of the paper documentation is really hindering that.
Thank you for sharing your perspective. Senator Sanborn?
Yeah, I just wanted to share some information that we received yesterday, at least preliminarily, with regard to some issues in the Constitution that are pretty difficult to go around with regard to changing the types of reimbursements that legislators receive so that we could be reimbursed for our at-home office expenses like toner and paper. That, according to some analysis that's being done, because we're hearing these, hearing this feedback, the analysis that we heard yesterday was that would be considered a pay increase within the same legislature, and that there's actually Supreme Judicial Court law court opinion on this topic with regard to reimbursements specifically, that the reimbursements can't change within the same legislature. We could only change them for the next legislature. And it's possible there is some more creative lawyering to be done to get around that. I think it's also possible that the executive branch could get us around that. But I did want to just share that I know that our leadership is working on this and is running down the rabbit holes of how that could work. I just saw Representative Libby pop in the chat that there's no need for reimbursement if materials can be picked up. And I think that's a fair point, and perhaps mailed as well. Right now, my mail is taking 6 days to get from Portland to Augusta. So I'm a bit concerned about the feasibility on a number of different fronts. About 4 years ago, I switched my workflows at my professional job to a much more paperless approach. And it took some getting used to, and now I really love it, and have figured out a lot of techniques for cutting down on paper, though I have a printer and can print things when I need to sit down and really edit something. I absolutely print it, but otherwise have gotten used to a paperless situation. So I think it's a combination, probably that's the final solution here, but I did just want to flag the issue with regard to the Constitution and let you know that there's serious and deep discussions going on amongst legislative leadership about how to get around this issue, because certainly the easiest way would be for us to reimburse toner and paper and let folks print out those things that are most pressing for them to print, because that's going to vary by person and could be very wasteful otherwise.
Any other comments? I'd just really like to weigh in and say I agree with all of you that we do all want to do our best for the state of Maine and for our constituents, and that there are a lot of things that are challenging about the way we are doing business these days. But I also just want to highlight that we've had 3 really intense days of orientation and hearings and meetings, and you all have sailed through them really well. And I feel like we have done good work, and we do have the capacity to do our best work in this forum. If we can fix some of the key pinch points that make it hard for all of us, myself included, to get our work done. And that is not having the the paper and the organizational skills that have been so amazingly provided to our committee previously by our clerk. And so, and we are working on it, as Senator Sanborn said. I mean, there's a lot of work being done to explore how we can, within the Constitution and the interpretation of the Constitution by the Maine Supreme Court, figure out a way to help legislators get the materials they need and to help us do our best work. And we'll keep working on it. And please reach out to me either in this format or by email and let me know if there are other factors in addition to what we've spoken about today that we should take into consideration. We are working on it. It's not something we've been able to fix yet, but we haven't given up. Are there any final words, Representative Babbage?
If I could make a correction, I mean, when we disbanded in March, I was fully supportive because, I mean, the legislature represents the state perfectly well, geographically, tentacles going to every section of the state, coming back to congregate, going back to the sections of the state, coming back to congregate. I mean, it was an opportunity with us being shoulder to shoulder to make it a, so that, but I want to clarify what I might have said. I believe I said that I was at an age where I'm more susceptible to being infected, and that I didn't want to infect certain members of my family. I don't want to infect any members of my family, but there were certain members I was, a little more concerned about. But I just wanted to clarify the record on that one.
I think it's safe to say we all want everybody we care about and everybody in our state to be as safe and as healthy as possible. On that note, when we reconvene on Thursday, I would like us all to be able to vote on the rules that have been circulated by email. And if you have questions, you can get in touch with me or Representative Harnett or with the leads, Senator Keim and Representative Hagan. So please do review the rules and be prepared with questions and to vote on Thursday. Is there anything else before we adjourn? We have a motion to adjourn. So moved. Thank you, everyone.
Thank you very much.
See you all Thursday, and thanks for your hard work today.
Good night now. Take care.